County Board of Zoning and Appeals, also known as the BZA. The board members who will hear your case tonight, to my right, we have Mr. Truslow. Mr. Neal is on his way. To my left, we have Mr. Jordan. Mr. Nelson is on his way. We're trying to get things kind of started quickly here today so that we won't prolong this meeting. And then to my immediate right, we have Mr. Kevin Hughey, who is our attorney. The staff members present tonight that will work with us is Ms. Clark, Mr. Dowling, Mr. Foster, and Ms. Working. Because the hearing tonight is a public fact-finding meeting, we're in compliance with the Freedom of Information Act and South Carolina Code 6-29-70. 15 days prior to the meeting, an announcement was printed in the Post and Courier. A sign was posted on or near the designated property, and a notice was mailed to the applicant or the applicant's representative, to the property owners within 300 feet of the property, to the parties of interest, persons, organizations, and news media that have requested declaration of our meeting have also been notified. Board members, the meeting notes for September 9th, 2020.
We'll do that at the end.
Oh, okay, yeah, because we don't have enough. Thank you for saying that. The Board of Zoning Appeals is a quasi-judicial body and has final decision-making authority. We have authority over the following: zoning, administrative decisions. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that an error was in order, the requirement, decision, or determination made by an administrative official in the administration or enforcement of any zoning-related regulations. A 2/3 vote of the quorum present is required to overturn the decision of the planning director in an appeal. We also have special exceptions. A special exception is issued by the BZA authorizing a particular use in the specified location within the zoning district upon demonstrating that such a use complies with all the conditions and standards specified in the zoning and land regulation ordinance, also known as ZELDAR. The BZA must find a special exception meets all 6 of the approval criteria in the ordinance in order to grant a special exception. A simple majority is required to grant a special exception. And then finally, we have a variance. A variance is a relaxation of the BZA's regulation of the ordinance where such an action is contrary to the public interest and where, owing to the conditions particular to the property and the result of the actions or the situation of the application, a literal enforcement of the code that would result in the unnecessary and undue hardship, and such a variance is consistent with Section 6-29-800 of the South Carolina Code, Title 6, Chapter 29. The BZA must find that a variance meets all 7 of the approval criteria in order to grant a variance. A simple majority is required to grant a variance. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering evidence pertinent to each case. If a member of the BZA finds the need for further information to clarify a case, the board has the authority to subpoena witnesses. It is understood that the rules of your neighborhood or subdivision are binding and that we can take no action that would negate their jurisdiction over your property. In addition to your testimony, our board has been presented written information submitted by the staff, by the applicant, or the applicant's agent for each case. This information is now considered evidence and is entered into the permanent record of this body. It is assumed that the information is complete, true, and accurate. In addition, we have been presented data assembled by staff for the purpose of clarifying the location, the application's effect on the surrounding property. Our board is empowered to approve with conditions, or to deny a special exception or a variance request. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of this public hearing. It will be mailed certified mail to the applicants and U.S. mail to the neighbors and the community interest that is listed. If an applicant request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted this evening are valid for 12 months after this meeting, and a one-year extension may be granted only if construction or development has been commenced or is being diligently pursued. However, an applicant case request is disapproved and the applicant wishes to appeal the decision of this board concerning a case, an appeal must be addressed to the circuit court. South Carolina Code 6-29-820 states that an appeal must be filed by the applicant within 30 days of the decision of this board, and it is mailed to them. Failure to file an appeal within that time limit deprives this court of its jurisdiction to hear a matter. Because this is a quasi-judicial body, everything said in this meeting must be complete, true, and accurate. All the information provided to the BZA must be considered evidence, and this board may certify contempt in circuit court if false testimony is made either in writing or orally. Each person that wishes to address the board this evening will be sworn in by the BZA secretary before providing testimony or evidence. In order to expedite this procedure, those wishing to speak to this board, I would ask that you please stand as the group, and our secretary will administer the oath.
Please stand and raise your right hand. I will say the oath, and you will say I do. I swear to tell the truth and nothing but the truth. I do. Thank you.
Thank you. I will now call each case by case number. Staff will present facts that are pertinent to each case, limited to 5 minutes. I will then call the applicant. The applicant will stand, state his or her name, and current address for the record before presenting testimony pertinent to each case, limited to 5 minutes. I would then ask for those speaking either in support or opposition to the case. They will follow the same procedure for identifying themselves and are limited to 2 minutes each. The applicant will then have an opportunity to reply to the opposition, limited to 2 minutes. And then the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application, stating specific findings of facts and conclusion of law. Tonight, we will hear 2 old business cases and 5 new cases. Ms. Working.
You don't have a quorum. You don't have a quorum.
We don't have a quorum, so thank you for reminding me of that. I tried to start, ladies and gentlemen, and hoping that we had more members to show up at this time, and I imagine the traffic on 526 and 26 can be a little cumbersome. So at this time, I did start. If anybody else walks in afterward, after that oath has been administered, we'll get them to stand up too, and then we'll get started with our meeting. So at this time, we're just going to take a brief recess, and we will resume when we get these other 2 members in, okay? Thank you. We're going to need the other 2.
It took me an hour. I left at 3:15 from home, and I know Mr. Neal has to come the same way. What is he there? What is he there?
IOP.
In Mount Pleasant.
I don't want to have to do it. I wouldn't want to have to do it again.
Right.
No, we're here now.
It was better with the strike when we had the longshoreman strike. It was a little better.
No movement. Oh, yeah, there is.
Yeah, your food not good. Bad traffic.
Yep. I told him, that I left at 3:15. It's terrible traffic. It's terrible.
Since Jesse resigned,
1, 2, 3, 4. We got 4 now.
since Jesse, he resigned.
We can start with 4 or 5. We got to have 5. We got 9 people. We got March and me, Stella.
Yeah, but one is off now, so we only have 8 members. One resigned.
I called him. He just had 2 small children. and a whole lot going on.
I gotta say, you have 4. That's who all we can.
Yeah, but Mr. Nelson.
What's his face resigned?
Can't somebody resigned that leave us with 8. Does that allow us to? I would hope so. That's what she's checking with.
It's just we can't pass anything unless we have 5 votes, I believe.
Say again.
Yeah, sure. Everybody agrees.
I think motion will still take 5. Motion will still take 5 to 3.
Then he call you and ask you that. All right, well, before you leave, give me your, whatever your number is. Well, it's, I'm talking about, I don't want to talk to the court, I want to talk to you. But I mean, I'll call this tomorrow, I think, Tuesday. I need to get more. What number is it? All we do is
Correct,
will this
but we
reach,
don't have a problem.
will this reach you?
Um,
No, no. How much case got this week? If you want to come over twice like that. How long will it take?
$1 or $2.
Tell me what.
Okay.
Whatever I got lunch, how long does it last?
About,
Oh, no?
I think you're, I have it on the side.
I'll get that done. I've got to get it done first. Because I need to get that behind.
They just said they didn't know any better. It was on the builder. I wanted to go further. Was it on them?
Right, have the right to ask. So, I can go either way.
There we go.
Oh, we got 5 now.
The man of the hour.
You are for sure, you're the man.
No, that's the.
Good to see you. Terrible.
It's kind of a great.
Okay.
Thank you for your patience. So we are fully staffed here tonight, this evening, and we will resume. So what we will do now, I read the opening comments, and what I'll ask now, board members, the meeting notes for September 9th, 2024, for the public hearing were sent to you. Are there any changes? If not, may I have a motion to approve
So move.
and a second? Second. All right. All those in favor, please indicate by saying aye.
All right.
All those opposed? Any opposed? It carries. So our meeting minutes for the 9th were approved. Thank you. And for you two who just came in, I read all the other information to save a little time. And Ms. Working, now that we have everybody here, our first case tonight is case BZA 08240. We had any other people before we go? I love having good counsel here, boy, I tell you. Did we have anybody else to come in that needs to be sworn in? Is there anyone else that just came in that would like to have information presented to this board? Please stand at this time.
And
Just
raise your
one?
right hand. I'll say the oath and you say I do. I swear to tell the truth and nothing but the truth. I do. Thank you.
Okay, thank you. So our first case tonight is case BZA-24-00804.
00775.
Wait, a minute. Oh,
I
I'm
guess
sorry,
that-
I'm not looking.
It's old business?
Yes,
Are y'all seeing
Thank
what I'm
you.
seeing?
no, I went down further. I apologize. So,
Okay.
yeah, it is 00775. Thank you.
Yeah. So this is BZA 0424000775. The applicant and property owner is Jose Vasquez. He is requesting a variance to remove a 28-inch diameter breast height DBH grand southern red oak tree and to remove an 18-inch, 32-inch DBH grand codominant stemmed live oak tree for a proposed 50-foot by 70-foot accessory dwelling unit ADU storage building at 4683 Lazy Creek Lane, which is TMS number 217-0000079 on Wabala Island in Charleston County. And please note that the original proposal was for a 60-foot by 80 building. The subject property and all surrounding properties are located in the agricultural preservation, AG 15 zoning district. The subject property is 23.97 acres and contains a single-family residence, a detached accessory building, and a swimming pool. The applicant is proposing to build a 50-foot by 70-foot metal ADU storage building south of the existing structures and 30.2 feet from the existing concrete drive. The previous request was 20.3 feet from the driveway. The 28-inch DBH grand southern red oak tree is located near the middle of the proposed footprint, and the grand live tree in question is 50 inches total DBH. It is located to the north of the proposed building. The following grand trees were administratively permitted to be removed. They were dead, diseased, or dying, and that was a triple 12-12-11 magnolia, a 24-inch DBH water oak, and a 26-inch DBH willow oak. And this is the site plan. You probably could see it better on your iPads, but he did provide some color coding, what trees they're requesting the variance for, and what trees were administratively permitted. This is the ordinance requirement, the 300-foot radius map, aerial, the zoomed out aerial, the posting. And we visited this property several times, May 16th, July 16th, August 9th, and September 20th, 2024. And this is a picture of the southern red oak tree, 28 inches. And this is the codominant stem live oak, 50 inches total. Subject property, and the site plan again. This is the revised site plan. So, like I said, hopefully it's showing up much better on the iPad PDF, yeah. The plat. As far as the criteria is concerned, staff stated that it may meet 1, 2, 4, and 7, that it may not meet 3 and 6, and it meets 5. The board may approve with conditions, or deny the variance request based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions. 1, the applicant shall mitigate the removal of 70 DBH inches by either A, submitting a mitigation plan for review and approval, indicating the installation of canopy trees no smaller than 2.5 inches in caliper, equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 926 of Zeldar, or C, a combination of both A and B. The allotted mitigation shall be in place prior to its removal. And 2, tree barricades constructed of chain link fencing shall be installed along all protected trees within 40 feet of disturbance prior to any construction pursuant to section 924 of the Charleston County Zoning and Land Development Regulations. 3, the applicant shall retain a certified arborist to monitor and treat all grand trees within 40 feet of disturbance through the duration of construction. The applicant shall provide a copy of the tree preservation plan to zoning staff for review and approval prior to zoning permit approval for construction. And that concludes the report for the revised.
Okay. Does any board member have a question for staff? Yes, sir.
Thank you, Mr. Chair. I'll be asking the applicant this as well, but the only change from their previous thing is the size of the building from 60 by 80 to 50 by 70. Did they mention why they went down, or?
And the location,
And the location?
yeah. Because in the initial meeting, oh geez, I think I forgot to say that. Sorry, I forgot to talk about the history. So you guys originally heard this on August 26th, and you voted to defer it. Since that August meeting, the applicant provided a letter from the Long Creek Plantation Homeowners Association, and that letter is dated September 13th in your packet, and the revised site plan. And then, like I said, they revised the color-coded plan and made the structure smaller. But this is the plan that the Long Creek Association approved, the relocation and the size.
And then one follow-up on the number of people that have voiced their opinion in opposition. Was there an increased number, or just these are the same ones from last month or months ago? Do we have any type of tally, or wondering how many? I mean, I counted 5 or something like that in opposition, 4 or 5.
Yeah, there were 7 total.
7 total in opposition. That included the ones from the previous, or these are 7 new ones?
Yeah, this is 7 total for the case, beginning of the case. Yeah.
Okay, thank you very much.
Any other questions for staff? Ms. Workin, thank you so very much. Is the applicant present? Yes, sir. Please come forward to the podium. Please state your name and address for the record, and please tell us why we should approve your application, sir. Yes, you can go ahead and bend that, so we want to hear every word you got. You won't break it, I promise you.
All right, perfect. All right. All right. We're good now. Thank you, sir. Thank you, gentlemen. Appreciate your time. My name is Jose Vasquez, owner of the property, 4683 Lazy Creek Lane, Wadmore Island, South Carolina, 29487.
All right, tell us why we should approve your application. This is your second time back.
Yes, sir. Thank you so much.
So you
Thank
made
you.
some changes,
Yes, sir, I did.
and please tell us about the changes that you made.
Yes, sir.
And tell us why,
Yes, sir.
and convince us otherwise.
Absolutely. Well, again, thank you for the feedback and the recommendations that you gave me the last time. Thank you for the permission of getting the deferral. I was able to reconvene specifically with my HOA and provide them what I was intended to do. And as an act of good faith to my neighbors, I made the choice myself to shrink down the size a little bit. I want to be a good neighbor to my residents, and I think that the opposition that you might see in the letters that were submitted were mostly due to the size. It really wasn't even so much the trees. So I believe that is kind of the theme of the opposition that we received. So as far as the shrinking of the size, it was just an act of good faith. I submitted the new proposed site plan, and obviously that is another change that was made, is that the site plan that you originally had seen was not the exact location of where the building was going to go. I believe the site plan that you received the first time was the first iteration, but since had changed. The only thing that had changed differently is now the new site plan is in the exact location of where it's going to go, and also the footprint of the building, which is the 70 by 50. I believe a modification to the site plan as well was the blue trees that you might see in the site plan, which are the ones that have been administratively removed or approved for removal, which was done by Mr. Foster. And then the ones that are in yellow are the ones that are actually being requested to remove any confusion that might be seen from the site plan.
Can we put that map back up, please? I didn't mean to interrupt you. Please continue.
No, sir, that's fine. If you just notice in the top right corner, it's just the blue, specifically stating the ones that are administratively permitted to be removed, and then also the ones that are in yellow that are being requested to be removed. As stated in the previous discussion, the 128-inch oak tree is, as you can see, right smack dab in the middle of the footprint. The reason why we've selected this location and the reason why we're actually selecting for that other tree, which is the 32 by 18, which is the triple trunk, is just due to the encroachment into the building, and also for the to preserve a magnolia as well as some other trees on both sides of the building. That location, as well as the proposed septic location, as well as the proposed well location, it is meant to cause the least land disturbance and least tree disturbance, as stated before. I'm trying to save a number of trees on the right-hand side of the proposed location, as well as a large magnolia that I'm really trying to preserve that provides beautiful shade. And it's a beautiful tree that the oak tree is now kind of encroaching into and will damage and probably cause it to fall here pretty soon. And that's just based on my own assessment. Willing to work and do what is needed to come up to an agreement. And I just appreciate your time and allowing me another opportunity to share with you what I'm proposing.
Thank you so very much. Hold on one moment. Let me see if any of our board members may have a few questions for you.
Yes, sir.
And right off the bat, we have a question. Go ahead, sir.
Shocker, I have a question.
No, it's no shocker to me.
So thank you for reworking your plan. And I'm just going to ask the easy question here. So I get the 28-inch oak tree. I've forgotten what the grade level is, but I'm trying to work with you work around as many issues as possible. Again, there are numerous letters in opposition to you, so that's what raises our alarms even more. The 18 by 32, which looks like it's a pretty good multiple tree, as I guess you call it, since I'm not a treeologist. Is there any way, I mean, you shrunk this thing from 60 by 80 to 50 by 70. I mean, I don't know what it would take to save that tree. You would probably still need some type of encroachment permit, but taking out the 18 by 32 just to save the canopy of a 12-inch magnolia. I mean, oak trees are better than magnolia if I had to rank them, but they don't go by my judgment. So I'm just wondering, you've modified this one time. I see your argument for the 28-inch, without a doubt. The 18 by 32, that looks like there could be some adjustments. But tell me why, and then tell me why these other people that are 7 people that have said not to remove these trees.
Yes, sir.
Why we should, what your compelling argument is.
If you see the picture of the oak tree, I mean, the oak tree only qualifies as a grand tree by like 3 to 4 feet up off the ground. I mean, you can tell, like, if you were to remove...
Pretty big tree in that picture right there.
What's that?
It's a pretty big tree in that picture right there.
Yes, sir. As far as the circumference, 32 inches is at the base, and then those 3 branches that are coming off of it are 18. The one that's to the left, that left picture, that left branch is the one that's growing into the side of the magnolia. If you can't see it, but just underneath that is the power box for our home, which is just underneath that branch and right next to the magnolia. The reason why we're selecting or requesting for that removal is that it truly is inhibiting that side of the property and the side of the building and it's not just to move the building into that location, it's also order to maintain the tree line and to not remove trees that are on the opposite side of the building. We know that we have to put a septic system in on the site plan, the proposed septic location is there as well. And the shifting of that building allows us to put the septic tank right there where there's no trees that have to be removed outside of the ones that have already been administratively approved. So if we have it and we can keep it in this location, it allows for the least amount of tree disturbance.
I follow up with one other, Mr. Chair.
Yes,
I noticed in one of the comments of opposition that there was an abandoned vehicle or something like that on the property. You want to address that?
Yes, sir. It's two S10 trucks. I'm big into old trucks. The purpose of the S10s, I had bought them, and I actually got a really good deal on them. Once I get my garage put in, like I want to work on old trucks with my boys, and that's part of the reason why I have the garage space in the size that it is that I would like to work on the cars with my boys and teach them about mechanics. This is a family project and a family building. You know, as you guys might remember, the purpose of the dwelling is for my in-laws
Right.
and my parents that are sick and will be eventually
And how much
in there.
space in that building is going to be the ADU?
I believe it is. I believe it's just under 1,100 square feet, which will be, which falls within the parameters of the HOA, and this has all been approved by them. And I make sure to get that letter from them. I gave them my plans and drawings. So the garage space, the dwelling size, everything has already been approved and is adhering to the guidelines that have been put before me in the HOA.
Thank you, Mr. Chair.
Okay. Yes, sir, Mr. Jordan?
So if you're gonna work on old trucks, which I certainly understand that's a guy thing,
Yes, sir.
what's your plan to keep the property environmentally clean?
Property environment cleaned.
If you're gonna be working on old vehicles?
It's all going to be maintained within the garage space. It's not going to be just like car parts and stuff thrown around. Right now, I just don't have the ability to store a car right now into the current garage that we have. But as far as the property and the environment, I'm planning on keeping it clean. It's just that truck being outside right now, I just don't have any other place to put it until we actually have the
How about
garage
fluids?
space. Oh, fluids?
Old trucks leak oil and everything else. I know, I had one.
I would adhere to, you know, as far as the cleanup of any oils, I would have the powder-based material that I would be able to put on the ground and dispose of them accordingly at the landfill.
I mean, what I'm getting at is there might be something leaking them now.
What's that?
There might be something leaking on them now that you're not aware of on the ground. Probably not, but maybe.
Okay.
Anyone else have a question? Mr. Truesdale? Yes, sir.
Thank you for coming again. I think this case establishes some of the good reasons why we occasionally have deferrals, so you can gather more information. We can have the benefit of that.
Yes, sir. Yes, sir.
I'm just trying to get a timeline on this. We out of the 49 people within your homeowners association, you had some that no more than 7, but I think at least one came from outside your homeowners association that objected.
Yes, sir.
Since then, I haven't seen that there have been renewed objections, but you've had your homeowners association architectural review board that speaks for the entire 49-person group look at everything carefully. They're there to represent the homeowners.
Yes, sir.
Y'all have been able to work something out that was satisfactory,
Yes, sir.
and then now you've come back.
Yes, sir. I tried to make the most of the time that I had given to me. So
And I understand this is a unique case, and these are often troublesome for us. But you have at least, it looks like 42 of your residents in your homeowners association have not had any objections. Your architectural review board that speaks for everyone has said that they approve of your plan. Is there anything more you can think you could add other than what you've given us? Oh, and then I've got one final question.
the only thing that I know of as far as the negative responses were again due to the size of the building. And as an act of good faith, again, I shrunk down the size of it because I want to be a good neighbor. So I did that of my own free will. As far as the trees are concerned, I think that there was some opposition of just like wanting to cut these beautiful trees down. But as I had stated in my previous time, is that, you know, the purpose of why we bought that was we love the privacy. We love the trees. As you can see from the overhead shot, it's completely covered with trees, which we absolutely love. But our priorities and our needs kind of shifted. So now we're trying to do the least amount of land disturbance, tree disturbance possible to still fit the needs of our family. The opposition was indeed for the removal of the trees. And I can understand just this is my own personal opinion. I can understand if it was beautiful trees that were right on the road line and I was just like hacking them down. I think that would be awful. I wouldn't want that. But these trees are trees that just my family and I see on a regular basis. It's tucked so far back on our property that even once we finish this garage building, you still will not have an ability to see the garage or any tree that was removed driving by the front of our home. So
That leads into my third comment or question
Yes,
for
sir.
you, is had you placed this proposed building elsewhere on your property, you could it sounds like you would have cut a lot more trees.
yes,
And
sir.
this results in saving more trees.
Yes, sir. But just based on the square footage of our property and where it makes the most sense, this is the best option we possibly can. If we had to relocate the property, we would have a number of trees that would be cut just based on just the overhead shot. We would have to put in new driveway and clear a lot more space, and we just don't want to do that. And again, the reason why we selected it just makes the most sense, and it's the least amount of trees that we'll lose.
I had one final question.
Yes, sir.
You have indicated both in writing and today and the last time that you had a sincere desire to save as many trees as you can.
Yes, sir.
And that leads me into a staff recommendation regarding mitigation.
Yes, sir.
It appears to me that you might have two alternatives. You could, on one hand, you could agree that you would, to run with the land, agree that there would be no clear cutting of the property,
No,
24
sir.
acres, or you could mitigate. Would you, I'm asking, and I'm not trying to steer you one way or the other, would you be amenable to, or would you think it'd be a good thing to agree not to clear cut your property so that trees could be saved in perpetuity, or would you rather do the mitigation?
I would 100% agree with that. I'm not planning on clear cutting my property. I mean, since I've been on my property, I think I've cut down maybe 2, and those were disease or dead trees that had either fallen or like the tops were off and it was just like a stump, and I cut them down for the safety of my children. So outside of just the need for the garage and what is needed for that space, I'm not planning on cutting any other trees down. And if I needed to, I would be approaching the bench just like I am now and making sure that I'm doing the things the right way.
Sounds to me like this is a win-win benefit. If you're agreeing that you would have an agreement that would run with the land, an agreement not to clear cut the property, that would allow the trees to stay, we would have thousands of trees more in the long run.
Yes, sir.
Short run and long
Yes.
run if we did that rather than mitigate.
Yes, sir.
All right, thank you. Thank you.
Board members,
I'll ask one more question. Just
Yeah, yes.
Mr. Vasquez, thank you so much. So the overall square footage for the structure you're proposing to build is 3,500 square feet, is that correct?
I believe that's the overall number. Yes, sir.
And 1,100 of it would be for the residents, for your in-laws or your parents?
Yes, sir.
Okay.
Yes, sir.
So then roughly 2,400 or so for RVs and working on old S10s.
Yes, sir.
That sounds like fun. Personally, I can see, just looking at it, the aerial view of your lot, there's not a lot of cleared ground on your property. And so I think it's pretty clear and compelling that you would at least have to remove one tree, through this process to put any size garage up there. The one thing that strikes me is when we're looking at our criteria, and particularly criteria number 3, that the need for the variance is not the result of the applicant's, that application of the ordinance to this particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. Can you speak toward how you meet that particular criteria?
Based on the needs that we have of our home and the purpose of like buying a lot of this size is to maximize its potential, maximize its use. My boys, they have, trails and stuff like that through that they ride their bikes and their 4-wheelers and dirt bikes, just being kids. As far as having an ability to build a building, I mean, I wish the previous owners had cleared out more than what we have right now. But as far as our needs are concerned, like I don't see any way possible to be able to maximize our potential and to actually meet our needs without having to remove additional trees. Again, you know, we've done our due diligence. I've had a private arborist come out as well as Mr. Foster separately come out. I had them both come out together and in unison come up with an agreement and walk through our property. They both agreed that this was the property spot that made the most sense to eliminate the least amount of tree disturbance. If they were to go anywhere else, we would lose a number of trees, and probably per square foot, we would probably lose maybe 4 to 5 grand trees because of how wooded and how heavily saturated we are with trees in our property.
Right. Your overall property is 24 acres.
Yes, sir.
Correct, give or take.
Yes, sir.
And just looking at aerial, probably 2/3 of it, maybe not quite that much, is a wetland on the backside of the property?
Yes, sir. The elevation, once you go past the cleared area and the fence line, it actually dips down into tidal basin and then it comes back up to the other side. So, I mean, I haven't even gotten to like walk the entire property because I'm still trying to learn it. But as far as workable space and footprint that allows, it's truly just limited right to like where our property is currently.
Do you have an estimate of how much land is cleared for the house and your other structures?
Off the top of my head, I would say like if you were to calculate everything that's actually cleared house and backyard space, I would say it's roughly 2.5 acres,
Okay.
maybe 2 acres at the most. It's minimal compared to how much property I do have and I tend to keep.
Okay. All right. I don't have any other questions.
Thank you, Mr. Nelson. Any other questions from the board? Thank you.
Got one for staff, but I'll let him finish.
You good? Thank you so very much, sir, for
Thank
your
you, sir.
testimony.
Appreciate
today.
it. Thank you.
Go ahead.
I just have a question. I'm trying to find the grade on the 2 trees, and I have a question for our wonderful staff arborist.
Mr. Foster.
I mean, I really don't have a problem with the 28-inch. I mean, any place he's going to pick, he's going to run into to losing a tree. My problem is not with number 3. My problem is with number 6 criteria, which is not the result of his own applicant's own actions, which means why can't he do a smaller shed instead of the bigger shed? He's trying to make it functional for his property. But if it's a grade A tree or B tree, the triple trunk tree, if he can move, he might be able to lose a bunch of smaller trees in another location that staff could handle. He wouldn't have to come to the Board of Zoning of Variances here. That's what I'm trying to find. I mean, if the tree is a C level or something where it's really bad, then that gives you the freedom to say, well, this tree is probably going to die anyway. Could we lose one of the trunks? He talks about the wires and the power boxes and stuff. Can you just educate me a little bit more on the triple trunk tree is what I'm really focusing on.
So the live oak is a grade B. It's in pretty good health.
Is it an A or a B? Or?
It's a B.
It's a B?
Yes. The red oak is an A. The live oak is a B. So if the tree in that good of health can stand to lose a significant portion of its canopy, if it was to be pruned off, like one of the major leads was to be able to pruned off, it could stand that. It can stand quite a bit of root encroachment if that was
Right.
if it had to. It
He's
could.
probably going to put a foundation out there with a big slab, and that's going to be a big disturbance to that root area. So,
It
I
is.
mean, I get it, but I just hate being able to say, why don't we try to keep the tree?
Right.
If we have to, and let the recommendation be that staff arborists can come up there and supervise or agree with taking off one tree limb if it encroaches on the building and try to save the tree. He's obviously wanting to save trees. I think it's just the easier way. That's where I am, board, is on trying to come up with a solution to get past the sixth one. But
Right.
I'm looking for suggestions or can support whatever.
If Mr. Vasquez was to keep that live oak and take off a significant portion of the canopy, that would require its own variance. Likewise, with keeping the tree and keeping the building in the same space would also require, I believe, a variance of.
For the encroachment?
I believe so.
Encroachment of the canopy or something?
Yes.
Well, maybe there's a solution out there in that role. If I mean, it might be a solution for all of it, so I don't know.
Well, did you find any other place that he could put
No, that property is entirely dense with canopy.
But I mean, some of the trees might be not needing variances. I mean, it's still got canopies and stuff, but I mean, he might be able to lose a 18-inch. I mean, he's losing other trees that
Right.
he doesn't have to come to us for. He's losing trees that staff has approval of, and I'm just trying to take it from this board.
Right. I think the area that he has now would be it would lose the least amount of trees possible. There's already a natural clearing there from what I can see, where the dense canopy has just not allowed sunlight to penetrate, and so there's not much there. It's just those two large trees. So in terms of putting it elsewhere, he might not lose, these two huge trees, but that area is clear as it is.
All right, well, you've given me good things. Mr. Chair, when we go to discussion point, or unless somebody makes a motion or whatever, I mean, I don't feel comfortable making a motion on this one because I could support most any motions.
Well,
but my
let
question,
me-
my question, just from where we're moving forward, is we are limited limited board members tonight. So a positive outcome is going to need, of our 5, is going to need at least 3 votes for the positive for this to clear. And I'm trying to get a positive outcome for people if people are on the fence.
Okay. Well, let me do this. That's a good
Yeah.
thought. I appreciate it. Let me finish up with the process.
Okay.
And let me see if we have anyone else. Do we have anyone else to speak in favor of this application? Do we have anyone else to speak favor of this application? Speak in favor of this application. Anyone to speak in favor? Do we have anyone to speak in opposition to this application? Yes, ma'am. Please come forward. Please state your name and address for the record.
I forgot
Thank
we had to
you.
go
I'm
through
Melinda
this.
Kelly with the Wadmalaw Island Land Planning Committee. I live on Allendale Plantation Road on Wadmalaw. We did submit one of the letters before, but a lot of what we talked about in the beginning had to do with the size, only because it violated the size requirements for accessory uses. It's our understanding that the neighborhood association didn't approve of the tree variance. They just looked at the building itself. So they were, I think, glad to see that it had been reduced, and that was good. That's not part of the variance, but the trees, we believe that. So the rest of our letter, if you have it in front of you, the rest of the letter had to do with 2 criteria that we felt that it didn't meet, and one was 3. And we felt that it didn't unreasonably restrict or prohibit. It may not maximize, the word he used, it may not maximize his opportunity, but we don't think it would unreasonably restrict or prohibit the use of the property. Since that last meeting when it got deferred, we've heard from neighbors at 4671, adjoining neighbors, and 4684, the Jacksons and the Henrys. And so we believe also that number 4, that it would be detrimental to adjacent property owners. They saw the trees as a buffer. That big tree was the 18 and the 36 as a buffer. And also they stated to me that they were very, very upset just to have grand trees taken down. So we added number 4, 3, 4, and we also looked at number 6 and thought that it was based on his own plan, his own action, that that criterion was not met. So we would look at this as, it's a shame to lose a large tree like that, both of them. And we thought that when he reduced the building that it was going to alleviate the need for having to take the trees down. And since it didn't, and the building wasn't really part of the variance at all, it was just sort of aside, but it was a big building, so it was nice that they're now in compliance, that it's not bigger than the house, which it was before. So we would ask that you deny because of the section 310.63, 310.64, and 310.66. Thank you.
One moment. Let me see if does anyone have a question? That's on Mr. Jordan's hand first. Go ahead, Mr. Jordan.
So does your group have any suggestions of what he could do further to win your support? Or
Well-
you just don't want him to do it at all?
No, we would love for, I mean, he's got a beautiful lot, lots of trees. It's just that he said that he hasn't really learned the property maybe, and if there's another spot, maybe not so close and convenient, but if there's another spot that might not have grand trees, as I believe you suggested, that maybe there would be a spot where there were smaller trees that wouldn't require a variance. So something like
There is
that.
another spot.
Sir?
Do you think there is another spot?
Well, I've never been on the property, so I don't know, but the neighbors have. They're right next door. So the Jacksons and the Henrys, and so they wish that there would be another place. And so that therefore, that's what we were thinking as a committee.
Thank you, ma'am.
Mr. Nelson.
Thank you.
One moment, we have one more question for you.
Ms. Kelly, thank you for coming tonight. In the deliberations with the Land Planning Committee, were there any on the committee that were actually in favor or not opposed to the project?
Everyone was opposed.
Okay. I know we did receive 7 letters of support as well as the 7 letters of opposition, and I guess that would include the letter from the HOA as well. So I was curious if any of those were a part of the Land Planning Committee or not.
I don't believe so. And I didn't know if the HOA committee supported the tree variance. I knew that they supported the building becoming smaller.
Right, and they supported the building, but I don't believe the HOA actually would have a say in the process of the tree removal. So
We didn't think so.
Yeah.
No, but all of our members, we have 18 members, well, we have 15 members, and they were all opposed. So
Are you guys opposed to them having an accessory dwelling unit and a garage
No.
there at all? And
no, I mean, if it's allowed, whatever the law allows, it's just when it comes to variances, we just look at them kind of closely, and especially with grand trees involved. So.
I can understand that, but if you have a situation where there's no way to build an ADU except for removal of a grand tree, is there any scenario in which the Wildemount Island Land Planning Committee would support such a
Well, if they
endeavor?
could move it to another place, and even if they had to cut other trees that were smaller, that weren't grand trees, that would be fine. I mean, I think he has relatives that need a place to live, and he's got storage needs, and so that part we weren't even looking at. We originally were. The reason I mentioned it in the beginning is because it was bigger than the house, and we saw the ordinances that precluded that. So, but no, it's fine to have an accessory use, whatever the zoning code allows. It's just the trees, the
Okay.
size of the trees.
All right, thank you, Ms.
Thank
Kelly.
you.
Okay. Do we have anyone else to speak in opposition? Do we have anyone else to speak in opposition? Very good. Sir, you have the right of rebuttal, so you have 2 minutes to respond to.
Yeah, sure. Just for clarity's sake, the only members that have actually come onto my property has been the Jackson family. I invited them over to our property just to be a good neighbor and an act of good faith to show them exactly where the property was going to go. The building is currently over 200 feet from my property line, and there's been a large amount of work on his property side with just brush and tree removal as well. I haven't removed anything from my property to my property line. So as far as the concern of being able to see this building, it's limited just due to the amount of growth that's in between my property, my actual property line, and where the building is going to go. The Henrys actually do live down the street from me in a cul-de-sac, but Miss Henry has not actually been on my property, nor has she seen the trees that are in question, nor can she see them from the road. It's just an opposition of just the tree removal. Again, I just make the statement that I've done my due diligence. Yes, on the other side of Tidal Basin, I have property that I have not explored. But again, it's on the other side of Tidal Basin where elevation drops and then comes back up, and I can't access that unless I were to cut trees down and make a bridge to get over Tidal Basin. As far as the only location where it's going to actually work and be feasible is that spot that's right to the side of the driveway. It's the least tree disturbance, least land disturbance, and it limits the amount of trees that will be removed. I understand your concern about the triple trunk, but again, my thought is a tree is a tree. So I don't want to cut a 20-inch or 22-inch tree that might just be on the cusp of a grand tree just to save the one. and there's a row of trees that are just on the other side of that proposed septic location that I'm trying to avoid cutting down. And that is the intent of why the location it is where it is. Again, I've been open with the HOA and with the neighborhood that if anybody had any questions or concern, to feel free to come to the property. I've made that very clear to the HOA president, and I was happy to show them through as an act of good faith and just being a good neighbor.
Does anybody on the board have a question for him?
Yeah, I do have a follow-up.
All
Yes, sir.
right.
Thank you, Mr.
Yes, sir.
So obviously, I'm perplexed on the triple trunk tree. Would you rather, and I put it bluntly, would you rather have us vote on a proposal as is, up or down, to remove this tree, or would you be amenable to trying some type of scenario where you lose one third of the tree trunk that would be overlooking or impeding the shed or whatever this facility is back here, to try and keep the 2/3 of the tree and in your location? Because if I remember your testimony, you basically said that the tree was obstructing the height of the building and stuff like that.
It's multifaceted, and there's there's 3 trunks, obviously.
Right. No, I
but there's
understand
one
that.
trunk that's impeding the building. There's another trunk that's going over the power box and going into the magnolia that I'm trying to preserve, and that would leave just one that's kind of like going straight up and over into towards the driveway.
All right. So my question was, which one would you rather us vote on? If you want us to just up or down on what's
Yes, sir.
submitted? That's fine.
Yes, sir. In transparency, it would just be the removal of the 2 trees.
No
Yes, sir.
problem. That's fine. Thank you, Mr. Chair.
Mr. Truesdale, you had a question?
No, I'm prepared to make a motion.
Okay. Thank you so very much for your testimony.
Thank you, sir. I appreciate your time, and thank you for giving me the deferral and another shot. Thank you.
Yes, sir. Okay, at this time, this case is closed to the public. Board members, do you have any questions of staff? Do we have any other considerations, questions, concerns? Mr. Jordan?
Maybe this is the wrong time, but I'd like to ask my colleague on the end, are you going to still raise that same question about us not having a full board before you vote?
I didn't raise it before. I mean, we have 5. We have to just have a majority, I believe.
That's correct.
Yeah, so.
I thought that's what you said a few minutes ago.
No, I'm fine with the 5. I mean, I don't have any issues.
Thank you.
Any questions,
No, sir.
comments? Okay. Well, gentlemen,
I'm prepared to make a motion.
okay. Let's hear it. Yes, sir.
I would make a motion that we approve this request for a variance. I'm very appreciative of the objection made by Ms. Kelly. It was well thought. It was well presented, and as always, we appreciate people who are vitally concerned about our environment. I believe that based on the presentation, that this will actually benefit, will be to great benefit of the public by creating permanently more green space than would ordinarily be in existence. As for my reasons for making the motion to grant the variance in this request, granting the variance in this case, this matter involves a request for a variance to remove 2 trees, as I understand it. They're defined as grand trees in a heavily wooded area in Charleston County, zoned as an agricultural preservation zoning district. It's on Watermalaw Island. This matter has some very unique and complicated issues, as Mr. Neal has pointed out, that have caused us to carefully, we hope we do it in every case, but carefully review everything that's involved and ask appropriate questions. For good reason, this case was deferred once before, and again, it points out the reasons why deferrals are often a good idea, because we can gather more information that would be of benefit to all of us. That was done in this case, and we found as a preliminary matter that the Architectural Review Board that speaks for the Homeowners Association has approved the design and cut down. They don't deal with trees necessarily, but they're speaking on behalf of presumably for the homeowners. They have clearly made clear that they approved the design for this building, and it's been indicated that there was really no other place that was reasonably suitable to build a structure. If there were a structure built elsewhere, however, it would result in two things. Number one, cutting of other trees that are going to grow, especially given the commitment of Mr. Vasquez to keep the area green, and I'm going to come back to that. There's been a good faith attempt to resolve this matter. We've heard a lot of pro and cons, both in favor and against this request for a variance. At the same time, there is a very much of a need, as Ms. Kelly has pointed out, to protect, and Mr. Vasquez, to protect our environment, and that's one of our concerns. We want to also, at the same time, prevent or protect against unintended consequences. I'll come back to that. This matter is governed by Zelda Ordinance Chapter 9, and in conjunction with the criteria set forth in Section 3.10.6, 1 through 7. And I'm mentioning this because if the matter went further, there'd be a clear record of what we've done and why. There are exceptional conditions. This is approximately 24-acre parcel of property that's heavily wooded. Cutting down trees or a limited number of trees is going to result in this circumstances with protecting other trees according to the commitment made by Mr. Vasquez. I'm aware of unintended consequences if we didn't allow this request for a variance. Perhaps he could place this structure in another place with more trees, or we could be sending a message to people to, it's often called the bird rule, to result in people cutting more trees than they would otherwise cut, which would harm everyone. The message would be, well, we're not going to let you cut these grand trees, but you can cut the rest of the trees under 24 inches at chest height, and you can do so without consequence. So we want to avoid that. Number 3 and 4, there's a concern that or if we denied, there would be an encouragement to cut more trees, whereas under Mr. Vasquez's proposal, he's going to cut less. We want to encourage them to do so and to protect our environment and protect our valuable trees. Condition 5 is obviously met, and I'm going through these again. Under 1, there are extraordinary or exceptional conditions regarding this particular property. I've mentioned those: the number of acres, the heavily wooded, the reasons that I would incorporate by reference that are stated in the response. 2, condition 2, this conditions do not generally apply to other properties in the vicinity. I've covered that. Number 3 and 4, I've covered that. Number 5, it clearly meets the conditions of number 5, which says that the Board of Zoning Appeals shall not grant a variance, the effect of which would allow the establishment of a use not otherwise permitted. That's why we're here. Number 6, the need for the variance is not the result of the applicant's own actions, but if using golf term, the lay of the land, where the trees are, where everything's situated, and what works best. I find that it's been a compelling case has been made that there's no other reasonable way under these circumstances, as I understand, has been confirmed by our arborist, to be able to build the building unless some concession is made. I'm especially persuaded by Mr. Vasquez committing to not cutting other trees, such as clear cutting the property, which he might otherwise be allowed to do, except for other grand trees, and we'd all be worse off. I understand that I asked the question, I think I was very careful, that he said he would commit to having this done to run with the land. So that will be of tremendous benefit to the public. Number 7, is the granting of the variance does not substantially conflict with the comprehensive plan or the purposes. We want to protect our environment. Mr. Vasquez is at the same time allowing people to have the use of their private property. He's committing to doing something that's going to ultimately benefit us greater than if we voted down on this. So I'm in favor of this, and I'm making this motion, provided that the conditions 2 and 3 are met. And then I would say for mitigation, I'm sure everybody's mindful of, not the public, but all of us are familiar with the Canton case that talks about proportionality and the 14th Amendment and what happens if we were wrong. Under condition number 1 for mitigation, I would allow Mr. Vasquez to have an option to mitigate or to commit to having the having a commitment that would run with the land, that he wouldn't clear cut the property.
I don't think the
And I would
board,
leave him that option if that's allowed.
I don't think the board has that authority.
Yeah, that's not
Okay, then I would, I would allow him to, I would rely on his commitment that he would have to require, we'd be required to present to staff that he would commit to not clear cutting the property and leave the trees. You can't do that?
The board does not have that authority.
don't have that authority.
He has the right to come back.
Then I wouldn't require mitigation under those circumstances, and here's why. If in the Canton case, the government had, like we have, they had a tree mitigation program. The landowner objected to what was required. It cost the government hundreds of thousands of dollars, and they lost at every level. They lost in the federal court in a per curiam decision. So if he's committing to keeping more trees, I would rather have more trees than risk having him cut less and do mitigation. And also, mitigation requires proportionality, and for those reasons, I wouldn't require mitigation.
So you're accepting all 3 criteria, 1, 2, and 3 that staff has presented?
No, he's not accepting one.
He's
Accepting only 2 and 3?
2 and 3. And I'm relying on the Canton case for the legal authority to not require number 1, given the commitment that's been made. If the commitment weren't made, I would require mitigation.
But the commitment is not binding.
Sir?
The commitment is not binding. You cannot order that he can't clear cut his.
Yeah.
Oh, I understand. I'm saying I wouldn't, under these circumstances, I would accept recommendations 2 and 3. I wouldn't require mitigation.
Require mitigate, I'm sorry, I don't have the.
Okay.
So there's a motion.
Is there a second?
Okay, so we have a motion on the floor that's been properly moved in second by, I guess I heard it from my left-hand side, Pastor Mr. Jordan.
Can we ask questions?
Yeah, well, yeah, discussion.
Mitigation is part of the ordinances that have been passed by county council for us to enact. And if there's a special circumstance, which you might be highlighting here, I mean, to be honest with you, I don't really want to support the motion because I don't want to support the 1 tree, but I'm going to wait to see if there's 4 other votes or 3 other votes, because I don't want to be the killing source. But at the same time, I'm clearly not going to support the motion right now because I think that mitigation needs to be involved. If you would add mitigation to it, then I would support it if I needed to support it. But that's where I am right now. But I think mitigation is key. I think the only other times that I have witnessed mitigation not be included for tree removal has been a financial hardship or something like that. Obviously, everybody's judged different. Every case is judged on its own merits. But they have not asked for no mitigation, so and staff is asking us for mitigation, so I would support the proposal of staff recommendations with mitigation. So for that reason, the current status of the motion, I will not be supporting it.
Okay. Mr. Jordan?
Does that mean us or the staff wants to ask him one more time? Does he want to mediate?
Oh, go ahead.
There's a recommendation. One of staff's recommendations is that there is mitigation.
Right, that's why I said that.
So,
You wanna ask him again?
Mr. Truslow was trying to omit the first consideration. And then Mr. Neal was saying that it needs to be included, which is also my thought and my feeling and my,
So then, with that in mind, if we're gonna ask him, would he consider that?
well, that's my next thing. It's one step at a time. I can't get, so I can do two things. I'll first ask if you would reconsider, and if not, then I'll bring it to a vote, and then it could go for a vote.
Yep.
Would you be willing to reconsider your motion to add the number one criteria,
Of staff recommendation.
the staff recommendation?
I would, and if I understood if Mr. Vasquez would agree to mitigation?
Well, that's the part of it. He doesn't have to
You
agree
doesn't
to
have
it.
to.
He doesn't have
You're
to.
making it part of your motion,
I would make one, an additional.
so you'll amend your motion?
I'll amend my motion, or restate my motion to include the
Staff
three
recommend-
recommendations
All
by
three.
staff, all three.
Jordan, would you go along with that?
Yes.
Okay, now, thank you.
Got it?
Any other discussion on that? So that motion had been changed, okay? And it has been seconded. Well, yes.
Yeah, you amended the second.
The amendment has been seconded. Thank you. Any other discussion on that? Very good.
Mr. Chair, Mr. Truesdale, I do appreciate your attempt to not hit the pocketbook of the applicants in these situations. But if the applicant doesn't have problems with the proposed condition, I think it's reasonable to leave in there, and as somebody that doesn't necessarily provide tree mitigation but provides other types of mitigation for a living, I do see the merits and offsetting impacts when we can.
If I can, I agree, and thank you. I was also thinking about the taxpayers, because if they had a case like, if we had faced a situation like Canton, the taxpayers would be on the hook for potentially for hundreds of thousands of dollars, and that's the last thing we want to see happen.
All right, let's bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Aye. Any opposed? Okay, it still carries. Thank you so very much. Congratulations, sir. After an hour, you've been granted approval to move forward with this application. Staff will give you information within 10 days, letting you know the next steps and process. Thank you so very much. Okay, so our next case will be done by Ms. Working, which will be case BZA 06-24-00792.
The applicants and property owners, Joseph Todd Manley and Meredith Hastings Manley, are requesting a variance to reduce the required 50-foot critical line setback by 22.4 feet to 27.6 feet, and the required 35-foot critical line buffer by 7.4 feet to 27.6 feet for an unpermitted swimming pool at 7753 Blue House Lane, which is TMS number 06900000013 on Edisto Island in Charleston County. The critical line location was established by the South Carolina Department of Environmental Sciences, SCDES, Bureau of Coastal Management, BCM. The subject property and adjacent properties are located in the Agricultural Preservation AG10 zoning district. Oops, sorry. The 3.11 acre subject property, 2.55 acres of highland, contains a single-family residence constructed in 2003 per Charleston County records. However, permitting for the residence began in 1999. The islands at Blue House Plantation subdivision was platted in 1985. Charleston County adopted required setbacks and buffers from the critical line in 2001. And you've all heard this case on August 26th, and since that time, the applicant has provided the neighborhood covenants and restrictions and 3 amendments to those restrictions, the bylaws creating the POA, emails from the neighborhood property owners showing their support, and a swimming pool construction agreement with the builder, pool proposal from the builder, and emails from code enforcement regarding the permitting. This is the zoning ordinance requirements, 300-foot radius. Sorry. Aerial posting, and here are the pictures of the pool. The survey of the property and the site plan and the plat. So regarding the approval criteria, we stated that it may meet 1, 4, and 7. It may not meet 2 and 3. It meets 5 and does not meet 6. However, the board may approve approval conditions or deny this request based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, we have the following suggested conditions. 1, the applicant shall use stormwater mitigation measures such as the use of rain barrels or rain gardens to reduce the flow of stormwater into the marsh. 2, the applicant shall provide an as-built survey of the existing house, swimming pool, pool deck, patio, vehicular parking layout. The survey shall include all vegetation in the 35-foot critical line buffer and critical line within 40 feet of the house and pool. 3, the applicant shall provide a planting plan showing the reestablishment of 35-foot critical line buffer with native vegetation within the as-built survey area for review and approval by zoning and planning staff. The applicant shall install landscaping based on the approved plan within 6 months of BZA approval. 4, the applicant property owner shall obtain all required zoning and building permits for the swimming pool within 6 months of this approval. Variance approval. Do you have any questions?
Any questions for Ms. Working?
I just have a
Yes,
quick one. Just to
Mr.
recap, I mean, if I recall this one, the reason, one of the main reasons that we deferred this, or the applicant asked us to defer it, was because we were really working through number 6, the need for the variance, and it became back and forth. Was it the applicants or was it the contractor? And you said something, they had submitted the contractor's contract in here, and did that help solve what we were looking for or something? Or was it just they submitted it and said, here it is, we're ready to move on? Is that basically what happened?
Yeah, I'd rather have them answer that.
That's fine.
Yeah, okay.
No, I was wondering if there was anything else that came across. And this is an existing pool, so really, I mean, there's not a lot we can do other than tell them to tear it out, right? Okay, thank you very much for working. Thank you, Mr. Chair.
Anyone else? Thank you, Ms. Working. Is the applicant yes, she is. Please come forward. Please state your name and address for the record, and please tell us why we should approve your application.
Thank you. Meredith Hastings Manley. And the address is 7753 Blue House Lane at Stowe Island.
Thank you. Am I correct? You are an attorney, right?
Yes.
Okay. Thank you. And the law firm that you represent?
Hastings Law Firm. It's just my own, I do family law.
Thank you so very much. Please tell us why we should approve your application.
Thank you. I'm not sure if you recall where we left off, but
Let's start over.
start over. Okay. So, without going through each of these elements individually, just to give you a brief history, the property was on the market for a long time. We bought it in 2019. It just wasn't selling. And once we bought it, I think, we don't know if this is the reason it wasn't selling, but we realized there was standing water creating a bunch of mosquito issues on the property where the pool currently now sits. We have a berm in our neighborhood throughout the whole thing. We didn't put it in. It, I guess, protects the ecosystem in the marsh, but it is a berm throughout the whole neighborhood. So when you have rainwater coming off the house, there's nowhere for it to go. We don't have a comprehensive drainage system like you would have in these neighborhood developments. We are in AG10 farmland. There is hardly cell phone reception. You have to stand outside on the porch to get cell phone reception. Each of the lots is, I mean, ours is 3 acres. You literally drive through a little farm to get back to the dirt road where the houses are. We put in the pool as a way to try to solve this issue with the standing water. We didn't want to do a retention pond because there was already a marsh. There are alligators in there. We have a family, dogs. Anyway, there was standing water. So there's already a natural slope in the ground, and we thought, okay, if we can just put in basically a big rain barrel to make it to where the water goes into this contained area, and we have a rain harvesting system. So it has a pool cover which protects from like leaves and sticks and stuff, but then there's space for the water to come in, the rainwater, and then these filters that filter it into pool water. So we thought we were doing something responsible. We built it during COVID. We thought that the contractor got the permit. I guess he thought we got it, I don't know. But we provided the pool contract that actually shows that he was responsible for getting the permit. It's at the top of the contract itself. Before we started building, we got neighborhood support, not required by our covenants and restrictions. We just sent an email out to everybody in the neighborhood to say, hey, here, we're going to put a pool in. Does anybody, just a courtesy, really. And you'll see all the emails from everybody saying we have no problem with it. So anyway, the pool was built without a permit. I didn't even know about it until somebody with a white truck with Charleston County pulled up. I actually thought it was regarding a lawsuit going on in our neighborhood where the POA is a defendant. And we're defendants in it because the 3 plaintiffs who filed the lawsuit have been doing illegal short-term rentals for years now. And they have filed a lawsuit back in early 21 to try to invalidate our covenants and restrictions. So I thought that's what it was about because there was reporting to the county of those illegal short-term rentals. But anyway, I guess it was retaliatory. I don't know, but I didn't even know we had an unpermitted pool until the truck pulled up in the driveway. So in any event, it's just to recap, it's AG10 farmland. We use the setbacks from when the house was built. The house itself is actually closer to the critical line than the pool is. So we just kind of looked around and said, hey, we like this location. It seems to be the same distance, not knowing that the house now is completely in that critical. I mean, it was probably built too close, but we didn't build it. It was built in 2003 and permitted in 99. There's no adverse impact on the surrounding properties. There are 2 just lots on either side of us. One of them has started building, but it's not complete. And we're asking for a variance to reduce the setback lines so that the rainwater continues to have a place to go rather than being trapped by the berm, and so we can continue using it.
Very good. Thank you. I believe Mr. Neal.
No, I'm good.
Oh, okay. Mr. Truslow?
Ma'am, I think I was the primary motivator behind asking for that you agree to a variance or move for a deferral so that you could gather information, including the contract that you had with the pool company.
Yes.
And you produced a proposal. I don't see that you signed this one, but I'll assume that this is the contract for the purposes of my question. Under the terms of your contract, and you're an attorney, you indicated that the pool company was responsible for getting a building permit. And I understood from that he alone was responsible for that, and you had no responsibility?
We didn't understand that we had responsibility, that he was just handling it.
You're an attorney, and the permit, your contract says that the pool company shall obtain a building permit for construction of the pool. If the permit cannot be obtained by him, then the customer shall attempt to get one. He didn't get one, did he?
Not that we never knew. He started building and,
Well, you knew that if he didn't have a permit, you were responsible for getting the permit.
that's what, yes.
And I would think everybody, and I don't mean this in a pejorative way, but everybody seems, I would think everybody, and especially attorneys, would know that if you would be required to have a building permit posted at your house, so it would be obvious. But you lived there. You
No.
didn't. Did you live there? Or did you not live there?
No, we don't live there.
You did not
We
live
do
there.
not, we never have lived there.
At the house.
Correct, it's a second home.
Did you? You didn't know that you didn't go out and look while the progress was going on to see whether there was a permit or not?
Sure, yes, we did.
You did. Did you see a permit?
No, I don't think so, because there wasn't one.
Okay. Well, that answers the part of that. The second thing is that it says in your contract that the customer, that would be you, shall be responsible for obtaining zoning variances. Did you get a zoning variance?
No, we did not.
And what, now, I'm asking this as a friendly question, but what's the excuse, when it says that you're responsible for getting that, what's the excuse for not getting that when I can see that you had a survey showing that where the pool was going to go was going to be in the critical area? Why didn't you get a?
We didn't know we needed any kind of variance. We got the survey after we found out that it didn't have a permit. We had to scramble. No one even was doing survey. The surveyors were too busy, but Larry Kennedy, he did it for us, just kind of.
It was COVID.
I mean, it was so hard to get a survey, but we got it done for this purpose.
When you purchased a house, you did not get a survey?
No.
I noticed that you said that the house is on the market for a long time, but the house had gone down dramatically in price from the time it was built in 2005 to when you bought it. Is that correct?
That's based on memory, yes.
Okay. So you don't live in the house, but you saw that you never saw a permit.
There wasn't a permit, so I wouldn't have seen a permit.
Didn't you send the permit to the builder?
Did I send?
Personally, did you send the building permit application to the builder, to the pool
No,
builder?
because I thought that he was handling that. That was what he was supposed to do. His job was to do it all, and that's what we paid him for.
All right. There's another.
Mr. Neal. Go
Yeah.
ahead, Mr. Trueslow.
Yeah, I'm waiting.
Go, I don't mind being.
Well, go ahead. Finish up.
Part of the criteria is that relate, and it's specifically prohibited acts, removal or excavation of soil in a buffer area. Would you concede that that was done? That there was excavation in a buffer area?
Yes,
Another prohibition is planting or grassing areas requiring maintenance. I can see that you've got grass around the pool and going down to the marsh. Do you regularly cut the grass?
yes.
Did you cut any vegetation that was down from where the pool is down to the marsh area?
Not that I recall.
With the excavation, what did you do with the material that was excavated?
Actually, funny enough, we sent out an email to everybody in the neighborhood asking if anybody needed some dirt, to fill in driveways or whatever. And the person who accepted it was Craig Williams, who just wrote a letter of opposition. He's one of the plaintiffs in the lawsuit that we're facing right now. So he came in and took our dirt.
So that's where the dirt went?
Yes, he has the dirt in his
Okay.
driveway now.
The next was placing structures in the buffer area. Would you agree that that has violated the law in this instance?
I'm sorry.
Your pool is in a, there are 6 prohibited acts, and I'll cut to the chase and ask you if you can agree, and I'll move on. Of the 6 prohibited things, you violated 5 of the 6 criteria under Article 4.2, 4.7.
Mr. Chair, I have to interrupt. We know that this is an existing facility. I apologize, Mr. Trueslow, but I just think we're going in a direction where we're already there. And we're trying to figure out if we're going to approve a variance or not. And I don't think the line of questioning that we're going into on something that we already realize is already happening is really going to help this case. Now, that's just me, but I think we're getting outside of the lines of where we're trying to go here right now. Mr. Chair?
I would just trying to find out where he was going in with this exploratory.
Well,
But
we've got 7 criteria.
Yeah, but there's no motion. There's no motion right now. We're just trying to ask for
do
details.
do you have another line of questioning that you would like to ask this witness?
I'll defer to Mr. Neal, let him.
Well,
ask what-
I'm lost now on all the details of the stuff. So what I'm going to do is I'm going to get back to, and I'm not a lawyer, so I'm not redirecting. I'm getting back to, I'm looking at the application based on where there's 2 lines that we have to deal with. There's the critical line setback, where it looks like there's not a lot of room behind this pool. And the pool was built in the critical line setback, I believe. So we're taking the critical line setback from 50 down to 27, so you're reducing it by about 22 feet or so. And then the critical line buffer, which is required at 35 feet, is going to be reduced by 7. So we're not losing a lot of the buffer, but we have lost a good amount of the setback. Is that a good summary?
That is, and as I said, I think the house itself, or the porch stairs itself, are closer to the critical line than the pool itself is, but.
And
yes.
the water, I don't know anything about water retention and rainwater systems and things like that. You're telling us that this new system that's been installed, that is, I guess, a catch-all for the pool, so basically you're refilling the pool with rainwater type thing, is helping the backyard and the buffer area.
Yes, so the ground naturally slopes, and then the tile that was put in, it slopes with it, and so there's the roof, and then the ground, and then the pool, and we keep a cover on it so that sticks and leaves don't clog up.
But the water goes through it?
Yeah, so that the water itself is going in rather than a bunch of sticks and stuff. But that is the purpose of it, so that, because otherwise, well, you do still have to fill a pool with a hose
Right.
with water.
No, I understand. And you have reviewed the recommendations by staff, and you're accepting of those recommendations that they were part of the proposal?
Yes.
Okay, I'm fine, Mr. Chair, thank you.
Okay, let's go down to this side. Any questions on this side? Mr. Jordan? Ms. Truesdale, I'll come back to you.
Well, what I was trying to get to, but I wanted Mr. Neal to ask the questions, is looking at the criteria that are required. The most obvious criteria, number 6, have not been met, the need for the variance. I was trying to hone in on whether the need for the variance was a result of the applicant's own actions, and we have the concept of vicarious liability. The builder is acting on her behalf, and if in fact something was done wrong and it's the builder's fault, what I would have liked to have seen was some, I'd be mad as all get out if I found our builder hadn't done something that he was supposed to, and I'd have an exchange of emails with him at least. But if she's wrong and the pool has to be taken out, she certainly has recourse against the builder if it's his obligation. That's where I was going with all of this.
Okay.
We have been in touch with him several times, and we discussed the permitting. He didn't have a lot of recollection. It was during COVID, so I don't know if offices were closed or what his capabilities were. All I know, we continued working nonstop, so we weren't shut down. Anyway, I don't know what his reason was. I've tried to find out of whether any permitting application was made at all. I sent even a FOIA request, but everything's put on hold because of this, so I couldn't even get that information. Anyway, it's my understanding that even filling a pool would cause damage because pools aren't meant to drain, at the bottom, and then it would make the water that comes into it just surface up to the top. That's just what I've learned. Anyway, we thought we were being responsible. We thought he had it handled because that's what we paid him to do. You can see that in the contract. And it is less of a distance from the critical line than the current house is. But we have neighborhood support, as you'll see, and we're asking for the board to approve a variance.
Okay. Thank you, Ms. Hastings.
I have one more question, if I could. When you bought your house, were you aware that your house was partially within the area of the critical line?
No, we've never done surveys or anything. So no, we didn't know.
All right, thank you.
And I guess permitted in 99, but built in 03. We bought it in 19. No, we did not know.
Thank you, Ms. Hastings, I appreciate
Thank
that.
you.
Do we have anyone else to speak in support of this application? Do we have anyone else to speak in support of this application? Do we have anyone to speak in opposition? Yes. I saw her hand first, if you don't mind. Oh, okay. Please come forward. Please state your name and address for the record, and please tell us why we should deny this application.
Hi, my name is Susan Kershaw. I live at 3605 Berry Hill Lane, Berry Hill Road on Johns Island.
That was 3605?
3605 Berry
Berry
Hill Road. Yes, sorry. I'm here representing the salt marsh and to speak about its role in the public good and safety of the low country. You all on the BZA have a lot of difficult decisions to make where you're weighing a lot of competing interests and you're trying to interpret very unclear phrases such as reasonable utilization and unreasonable restriction. It's a lot of nuance and balancing in your decision making. I don't envy you. I believe that the threats posed by sea level rise and larger and more powerful storms need us to put more weight on the side of the marsh as you're balancing these competing interests. The marsh protects us and our land and our homes, and it's going to become even more important as we go. As a matter of public good, we need to add weight to protecting the marshes. However, in this particular case, I'm going to get more specific. This pole did encroach in the buffer zone, and I believe that it does not meet criteria 1 or 2. In the applicant's application, they don't even state ways that it is different from other properties in the vicinity. It's very similar to other properties in the vicinity, and which all have marsh-side homes, and other lots are actually skinnier than theirs, and so less appropriate to have more development on the lots. I don't believe it meets criteria number 3. It's a beautiful lot. They have so many ways to utilize this lot. I don't think a pool is necessary to reasonably utilize the lot. And I don't know if it meets number 6 or not. That's a good question about the contract. However, I do believe it is worth taking the pool out. It is currently a danger to the marsh. It is a, 8-foot deep, hard edge right in the buffer zone. And I think it's worth taking it out, and there are other places it can be put. There's on the other side of the house by the driveway, it could be put there. And I don't think it would be an undue hardship on the, I'm out of time, on the owner, because the contractor would have to take in a lot of that.
Thank you. So let me see if anyone up here has a question for you. Mr. Jordan?
If somehow they did move it to what you said, would you be happy with this application?
Oh, yes, because it would be outside of the buffer
So you
zone.
wouldn't mind them having a swimming pool?
No.
But what about the environment that the marsh?
If it's outside the buffer zone, it's not endangering, we have that vegetation barrier.
How are y'all?
Well, thank you. Please state your name and address for the record, and please tell.
Recently inherited my mother's home at Blue House. So I've first I want to say I'm not an environmentalist. I don't I will say I'm the third generation going down to Edisto, and I do think that looking at my town, that to have respect for the property that we have, I think is really important. You know, and I find it, well, anyway, so I just got that out there. I'm new, hi. But my understanding is that, first I want to say the 30-year or the, what did she say, the illegal short-term rentals out there that the property owners are suing the POA for, I would be one of those.
Ma'am, I'm sorry, can you focus anything relevant to the application, the issue about the short-term rentals? That's not relevant to this board.
Yeah, no problem, no
Thank
problem.
you.
But I was just saying that I don't think it has anything to do with it. They're separate, so why it was brought up to start with, I'm not sure. It says that the homeowners agreed to the swimming pool. The swimming pool, we agreed, yeah, sure, if you want to have a pool on your property, you should be allowed to have a pool on your property. But never did anyone in our place agree to have an unpermitted pool. And I guess the reason I'm here is because I just want things to be done right. I don't know this for a fact because I'm new, but I've been told that the owners of this home are lawyers.
She admitted that she was an attorney.
Yeah.
Yes.
Yeah. And have done business with this swimming pool company before, from what I'm told.
So let's stop with the hearsay.
Okay, okay. Well, I don't think that it should have gone down like it did. I don't think that, and I don't think it should stay because of it.
Let me see if any board member has a question for you. Any? Mr. Jordan?
So you say you don't think it should stay, but would you be agreeable with what the other lady said she would be agreeable to it moving somewhere else?
Sure.
So
But we've
then-
lost 10 foot of
So
land.
then at that point, they could have a swimming pool, is that what you're saying?
Yeah, she can have a swimming pool. It just needs to be permitted and play by the rules like everyone else.
Thank you.
Anything? Thank you so very much for your testimony
All
tonight.
right, thank you.
Thank you. Do we have anyone else to speak in opposition to this application? Do we have anyone else to speak in opposition? So at this time, Ms. Hastings, you have the right of rebuttal. At this time, limited to 2 minutes, please. Thank you.
Thank you, Your Honor. The opponent, Ms. Kershaw, has not been to our property. She resides on Johns Island. This property is on Edisto Island. She might not be aware that there's a berm that is built up between the marsh edge and the property edge. And that does, my understanding, protect the ecosystem, but it also doesn't give the rainwater a place to go. It actually traps it in, at least with our property. I don't know about the others. The second opponent, Ms. Sinclair, she is one of the plaintiffs in the short-term rental lawsuit. And I think her deposition is scheduled for tomorrow. So the timing of this, I would just like for that to be considered. Thank you.
Oh, one moment. I'm sorry, there's no rebuttal up here. Okay, Mr. Nelson.
You mentioned a little while ago that you submitted a FOIA request to the county for a copy of any correspondence between your builder.
Right, applications, anything that I could find, and there's a hold, so I can't get any of that.
And I'll ask staff this as well, but you said you did not receive a response on a FOIA request?
Well, it said hold because of this. So everything's on hold. I can't get any information to supply other than what I've provided.
Huh, okay. Thank you.
Mr. Jordan had a question.
Oh, okay.
I believe you stated that you had been in contact with the builder.
Yes.
Have they offered any suggestion how to resolve this?
No, not at all. No.
Okay.
There have
thank
been several attempts.
Mr. Downey, you had testimony that you wanted to present, sir?
In regards to the FOIA, we did receive the FOIA for this application, for this property. What was responded to was that the property itself had a hold because the property is in violation. However, the information for the ticket was given to the applicant.
Thank you for that important reference. So I'll start closest to me, Mr. Truslow.
Thank you again for coming here. I'm trying to get a timeline of exactly, I saw when your proposal for or a contract, if you will, was for the pool was made. I'm trying to get a timeline of when it was built. Do you have a check or anything that you have provided that would tell us with more definitiveness when the pool was actually built?
Not with me, but it was, I just remember it was during COVID, and it was, which COVID was mainly 2020, or at least the start of it. No, other than, I mean, that's just off the top of my head, though.
You didn't bring a check or anything?
No.
All right, and I'm going into, this relates, the cost was some $69,000 in 2020 dollars? Was that about the cost?
Yes.
And would you agree that by May 7th, 2021, you knew that there was no permit for this, there had been no permit?
I learned the day that the code enforcement truck pulled up.
I
So
didn't hear you.
I learned about it the day that the code enforcement truck pulled up, and I don't remember that date. But there's correspondence in the file of, that I supplemented with, of who we spoke with, and it would provide that date.
I'm looking at an email that you submitted dated May 7th, 2021. And it came from zoning from the county that told you that there was no permit for this pool. Is that correct?
Yes, that's correct, and that, it should say the name of the person.
His name is Mr. Darren
Munzberg or something, yes.
All right. Knowing that you were told in by May 7th, 2021, that there was no permit, why at that point, code enforcement came to see you when, in 2024?
Whenever that email is from Derek Munzberg, that's when it all started.
Okay. Why then, having gotten this letter and passing this on, I think, to the pool company, did you seek a variance at that time?
No, the first thing we did was try to figure out what was going on. Try to get in touch with the pool company, try to.
So let me do this, and the sake of time, I'm going to thank you for your testimony.
Got a question.
I understand. I'm going to allow one more question, okay? If he want, Mr. Nelson, if you want to, not Nelson, Neil, if you want to follow up on that with one question, then we can, and then we're going to.
I don't have any questions. I think we're way off the scope
I
of what
understand.
our commission is here for.
I understand. Mr. Jordan, do you have anything related, sir?
Yes. In fairness to you, you didn't hand them $60,000 in cash, did you?
No.
So somewhere, if you had to produce it, there's a record somewhere that you paid for it.
Yes, my husband wrote the checks.
Right.
I mean, I was hardly even involved, but, I mean, yes.
Thank you.
Okay, so thank you so very much for your testimony.
Thank you.
Mr. Truslow, we will come back into deliberation with you on that, okay?
I was done.
Okay. So now the case is closed to the public. Board members, do you have first any questions of staff regarding this case? Is there any brief discussion limited? Let's try to limit it to 1 minute if we can. Go ahead.
I'm ready to make a motion. I'm going to put my glasses on because I will not be able to see. As per case BZA 0624000792, the critical line setback and the critical line buffer, I move that we approve this case. I will also go through the seven criteria for zoning variances. But before I go through those 7, all of us up here go through our own version of why to approve things and how to meet these criteria that are mandated for the Board of Zoning Appeals. I constantly struggle with number 6 and number 3. All the other commissioners up here struggle with whatever reasons, and it's how we make these things fit. And for my motion on this project, I look past the issue of is it already approved, was it built with prior approvals, and what's going to happen. And I think there'll be a greater disturbance if we take the pool out and start back to square one, because we've already disturbed the land, and I want to keep as much land not disturbed as possible. So because of that thought process, I'm going to move for the approval of this project based on that I believe it meets all of the 7 criteria. There are extraordinary and exceptional conditions pertaining to this piece of property. I don't know how they got a pool back there. In a perfect world, we would put the pool on the side, but I think it would be a greater disturbance to the ecological system by tearing out an 8-foot deep pool and then disturbing other land on it to put it back in. So I'm fine with that. This is clearly an extraordinary piece of property. Condition number 2, they generally apply not to the other property in the vicinity. There's no other pools around that area. I think this is a unique piece of property. Criteria number 3, because of the conditions, the application of this ordinance to this particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. As close as this pool is back to behind the house, I don't think it restricts anything on any other property around it. The authorization of the variance will not be substantial detriment to adjacent property. So just like I stated right there, I don't have an issue with it. I don't think it's affecting anything next door whatsoever. We haven't had any opposition from a neighbor. The applicant testified that there's vacant pieces of property on each side. Number 6, the need for variance is not the result of the applicant's own actions. That's a tough one for me, but I think we would have a greater problem if we needed to move the pool and only had 1 foot left in the barrier zone, the zones, the critical line and the critical buffer area, and they came back, they'd be right in front of us again for another iteration of the pool, and they'd want to put it, and we might have it a bigger pool. So I really think, as much as it's tough to swallow this, I think the better solution long-term is to learn from this from a standpoint of our staff, of maybe there's more visits we can put out to the different stuff, but I think tearing it down and rebuilding it right on the other side is not a good solution. And number 7, granting of the variance did not substantially conflict with the comprehensive plan or purpose of the ordinance. Obviously, the HOA is fine with a pool out there. Everybody out there is fine with a pool. It's just it's built too close to the critical line, buffer area. So for those reasons, I'm hoping I'll get a second, and I hope it'll pass.
Conditions?
And please include all of staff recommendations. Thank you.
We have a second.
Second.
Seconded by Mr. Nelson. Okay. We have a motion that's been properly moved and seconded. Do we have any discussion? Let me say that. No, ma'am. Okay. All those in favor?
Ma'am,
Please.
ma'am. Okay, you can leave, but please don't threaten anyone in here. Well, if I need to call the authorities, you need to leave, ma'am. I don't come here to babysit.
Okay. Now, all those in favor of this motion, please indicate by saying aye and raising your right hand. Aye. Okay, those who oppose? There's 2. So it's 3-2. It passes. Congratulations, your application has been approved. Within 10 working days, staff will give you information letting you know the next steps in the application process.
If she said under number 6, it was their own fault.
Ma'am,
Oh, my goodness.
Okay, so let's take a, at this time,
that
let's
note,
take a 5-minute recess and we'll
Cooling down period.
yeah.
It's so much fun to be on this board at times.
Somebody will probably go with that.
Yeah, they violated everything.
At this time, we will reconvene and we'll start back with our next case, which will be done by Mr. Joshua Downey. Would be case BZA 07 2008 24 0084.
So
79, excuse me, 779. Why am I getting ahead of myself? 799. Now I have dyslexia, right?
Right. Everybody's having a little trouble tonight. All right. So BZA case 0724000799. The applicant and one of the property owners, Christina L. Johnson, is requesting a special exception to establish a short-term rental, extended home rental in the low-density R4 zoning district at 4435 Betsy Carrison Parkway, TMS number 204-0000019 on Johns Island in Charleston County. The subject property and properties to the north, east, and south are located within the low-density R4 zoning district. The property to the northwest is in the community commercial CC zoning district, and the property to the west is located in the agriculture AGR zoning district. The property contains a single-family residence with 3 bedrooms that was constructed in 1998. Per Charleston County records, the applicant would like to rent 3 bedrooms in the single-family residence, and the applicant has also shown 6 parking spaces on their site plan. So that is the definition for short-term rentals. That is it. That is a zoning map of the property. This is the 300-foot radius map. That is the subject property. A zoomed out aerial view of the subject property. So staff conducted its site visit on September the 20th and September 24th, 2024. So those are pictures of the single family residence and the parking. Some of the surrounding properties. This property sits on the corner of Resurrection Road and Betsy Carrison Parkway. That is the site plan of the property. A tenant notice showing evacuation routes in case of an emergency, along with all other rules and regulations of the property. The recorded plat. So staff believes that all 3 of the criteria for this application may have been met. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 0724000779, a special exception to establish a short-term rental, extended home rental in the low-density R4 zoning district at 4435 Betsy Carrison Parkway, TMS number 204-0000019 on Johns Island in Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. The board may modify any of staff's recommended conditions below including but not limited to restricting the number of days that the short-term rental may be rented. In the event that the board decides to approve this application, the board should consider the following recommendations by staff. Prior to zoning permit approval, the applicant shall complete the limited site plan review process. The use shall comply with all requirements of Article 6.8. The property shall not be used for more than 144 days in aggregate during any calendar year, and the property owner shall be responsible for ensuring that the tenants comply with the Charleston County Noise Ordinance. Are there any questions of staff?
Do we have, okay. Mr. Neal, I see you with your hand up, sir.
Thank you, sir. A couple standard questions here on our extended home rentals. Have they been doing the extended, the regular rentals before?
No,
This is
sir.
a brand-new application for
This
everything?
is a brand new application for the extended home
All
rental.
right, and then this is obviously no HOA in this area or anything like that.
No, sir.
And are there any other, have there been any other approvals of extended home rentals anywhere in this vicinity?
Not.
This is a new one to me, but I've
So
only been here.
looking at the
a year
zoning
and a half.
map, this is the zoning area here. This is the subject property.
Yeah.
Up here is Hope Plantation, the
Yeah.
old
Oaks,
the
Hope-
Kiowa
Hope.
River Estates now.
Right.
And then Kiowa River is not far from here. There are several short-term rentals in Kiowa River, but none in this vicinity or on Resurrection.
Okay, I'll save my other questions for the application. Thank you, Mr. Chair.
Yes, sir. Any more questions on my right? Any questions on my left? Thank you. Thank you, sir. Is the applicant present? Please, if you would come forward, please state your name and address for the record, and please tell us why we should approve your application.
Christina Johnson. I live at 207 Heaton Drive in Lexington, South Carolina.
You came a long way to see us.
Yes. So this is Ayers property. Sorry.
Oh, now you broke out a little
I think
thing.
I may have broke it. I'm sorry.
I'm just teasing.
Oh. Anyway.
Joshua, would you help her? Oh, you got, please.
Add a fee to her application.
Thank you.
Thank you, sir.
So this is Ayers property, and the reason why I'm bringing this forth as far as doing a short-term rental, one of my brother was living in the house in August of 2003. He just left and abandoned the house, and there's nobody living in there. And so my concern is, number one, for the upkeeping of the house going forward. And as of today's date, he's still not living in the house. He's somewhere across country. I don't know. And so the house itself was, my mom died like 7 years ago, and the house was going down anyway. So my concern was the upkeeping of the house, the property as well. And he did not do a very good job in doing it. He was in and out of the house, lights being turned off, not keeping up with the yard or the shrubbery bushes or anything during the time that he was living there. Also, we've had problem with him paying or helping to pay taxes and insurance. So with all of that in mind, after he left and trying to contact him and wondering what was his whereabouts or what he's planning on doing, was he coming back or not, and trying to contact with him and seeing what was going on, getting with my other siblings like 6 months later, and just saying, hey, we need to do something with this property. It's going down. It doesn't look good from where it is. It's right there near Kiowa, and to me, that's a good entrance and exit area, and you want to keep that area up. My mom has always kept that area up throughout her time here on this earth. So just wanting to keep that up, I presented the situations to my other siblings and say, hey, what do y'all think? Should we just clean up the house and put the house up for rental? Everybody at the time agreed, which I told them that I will proceed. My two brothers presented the situation to me, say, hey, we got to do something with this property. We got to keep it up. And once talking to all my other siblings, and they agreed that we needed to do something, in addition to my brother who left the property, had added on, okay, well, do this and do that as well. We proceeded and started fixing up the house. And by fixing up the house, we want to rent it out so we can continue to keep it up as we go forward.
Okay. Yes, sir. You have a question?
Yeah, I do. Well, first of all, I applaud you for trying to do everything you can to keep the property collectively together. I've seen a lot of instances with heirs properties over the years, and so I've got experience with that. So wonderful. I love what you're trying to do here. If my fellow commissioner, Mr. Marchant, was here, he would ask, how are you going to market the property? Which, VRBO, Airbnb, one of those things, and are you going to have a property manager available in the region? Since you live in Lexington, it sounds like your family is dispersed a little bit over. So tell us a little bit about how you would handle the management of the property for issues that may arise when you're in Lexington, so that we don't have concerns for the neighbors.
Sure. And if you would like, my brothers are here. They're owners as well, and they can talk on their behalf. But my brother, Jimmy, he lives right next door to the property.
Well, that answers that. So he'll be the property manager?
He'll be the overseer, if nothing else.
And how are you going to market the property, like on VRBO or something like that?
Yes.
Okay. All right. That answers me, Mr. Chair.
Thank you. Any more questions on my right? On my left? Thank you so very much for your testimony
Thank you.
today. Do we have anyone else to speak in favor of this application? Do we have anyone else? Yes, sir.
Great solution for error.
Good evening.
Good evening.
It's been a long day and a long evening. It's good to see you, and I am praying that you all won't be here too much longer.
Your name and address, please, sir?
Name is Jimmy Ravenel, 4433, which is next to 4435, Betsy Carrison Parkway, Johns Island, South Carolina. There's a lady by the name of Clementine Susie Ravenel. Her friends and people who are known her from Johns Island calls her Clam. She's clam because of her relationship with folks from Seabrook Island and Kiowa Island and her long-term relationship on Johns Island, one of the first homes down on that end before you get to Kiowa Island. One of the things Clam taught her children, she is a single mom, raised 9 children, taught us to treat people right, become responsible, work hard for what you want. She taught us to be able to help somebody else. That's all I have been doing in my 30-some-odd years pastoring a church. And I try to treat people right, and I want things and great things to happen for people, especially in the community where we are. Because our mom worked so hard, it would be a disgrace and a shame for us to let that property that she worked so hard to establish and build go down. So that's why we're here, to do this short-term rental, to do what is best for the life and the legacy of Clementine Susie Ravenel. I want to thank you for hearing me, and I know that you all are respectable men and you all understand what we're trying to do. And I appreciate your time for allowing us to come here just to get this ball rolling so that we can keep things moving. As far as property management, yes, I've been keeping the property forever, and we're going to continue to do just that. We want to maintain that property and keep it looking good for where it's located. Thank you very much for your time, and have a great evening.
Just one more. Any questions?
None at all.
Thank you, sir. Anyone else to speak in favor of this application? Yes, sir.
All right, good evening to the board.
Yes,
Thomas Johnson Jr., 207 Heaton Drive, Lexington, South Carolina, husband of Christina. Over the last 7 months, we've been doing the repair on this property to bring it back up from a state of disrepair to what it is today. So we've invested in it tremendously to get it back into a good shape and have it as something that is desirable and potentially rentable space. I know that there's not other short-term rentals in this particular area, but its proximity is only about a 2-minute drive to the gates of Kiowa and Seabrook. So we believe that it'll be a good, viable option for a rental. Some of the concerns that people always have when you move to short-term rentals, traffic in and out, but in this particular case, it's a dirt road that leads to the property, so it's not going to be a tremendous impact or increase in traffic. We do have a commercial property directly across the street, a restaurant, so any potential increase in traffic from use of this as a short-term rental is not going to significantly add to the traffic in the area. We've got provisions in the application package to make sure that any renters would adhere to noise requirements and party requirements and things of that sort, so that would be no negative impact to the neighborhood or to the immediate neighbors. Thank you so much.
Thank you. Any questions? Thank you so very much for your testimony. Do we have anyone else to speak in favor? Do we have anyone else to speak in favor? Do we have anyone to speak in opposition to this application? Do we have anyone to speak in opposition? Very good. This case is closed to the public. Board members, do we have any questions of staff? We have any other discussion?
No, I'm ready to make a motion.
Okay, sir, please
I make a
proceed.
motion that we approve this request, this matter, and it's well presented, and thank you for coming all the way from Lexington, and we appreciate it. This matter involves a request for a special exception to establish a short-term rental on Johns Island, extended home rental. The Charleston County Ordinance, Chapter 6 and 6.1 and 6.1.3 govern this application. The criteria set forth in 6.8.2C 1 through 3 set forth the relevant criteria. All the criteria have been met by clear and overwhelming evidence. Well presented. This is compatible with the existing uses and will not affect the general welfare of the community. It's consistent and compatible. It's for residential use, albeit on a temporary basis for short-term rentals. The adequate provisions for setbacks, buffering, and such, and landscaping, parking have all been addressed. It's in compliance with the applicable rules, laws, and standards in this case. So I would move to approve this, provided the 4 conditions that are recommended by staff are met.
Very good.
Second.
We have an application,
We
a
also
motion.
We also have a family member who lives next door who I'm confident is going to ensure that the property will be well cared for, and there's been no objection.
Good. We have a motion that's been properly moved in second. Any question or discussion? All those in favor, please indicate by saying aye and raising your right hand. Aye.
Aye.
Any opposed? There's none. Very good. It carries. Your
Perfect.
application has been approved within 10 business days.
Perfect use
Working
of their
days.
property.
You'll be getting information from staff letting you know the next steps in the process. Once again, congratulations and have safe travel back home. Very good. So our next case will be done also by Mr. Joshua Downing, case BZA 0824-00802.
Yeah, we're gonna
So you go
switch
switch
801 and
802
802 around. Right.
Yep.
We're doing what?
So BZA case 0824-00802. The applicant and property owner, Robert G. Roll, is requesting a special exception to establish a short-term rental, extended home rental in the low-density R4 zoning district at 2040 Wapu Drive, TMS number 343-0300141 on James Island in Charleston County. The subject property and surrounding properties to the north and west are located in the low-density R4 zoning district. The properties to the east and south are located in the James Island Maybank Highway Corridor Overlay Community Commercial Zoning District. The property contains a single-family residence with 4 bedrooms that was constructed in 1947 per Charleston County records, and the applicant would like to rent 1 bedroom in the single-family residence as shown 4 parking spaces on their site plan. Again, that is the definitions in the section of the ZLDR dealing with short-term rentals. That is the subject property.
Where is this?
The radius map, an aerial view of the subject property.
Can you just, where is this on Wapu Drive? I'm not familiar with this area.
That is in the
Riverland Terrace?
Riverland Terrace area, yes, sir.
So that's right there at the fork where Wapu extends over and?
Correct.
So that's commercial right down there at,
yes, sir. This is all commercial.
Where's Maybank?
Maybank is further down this way.
That way?
So see, Maybank is right there in the corner.
Oh, yeah.
Yep.
Okay. All right. I know where this is now. Okay.
Yep.
Thank you.
So the 300-foot radius map, an aerial view of the subject property, along with the zoomed out aerial view of the subject property. So staff did conduct its site visit on September the 20th and September 24th. The single-family residence and the parking, some of the surrounding properties. That is Wapu Drive, Plymouth Avenue. This property is on a corner lot. That is the site plan of the property, the site plan, along with the tenant notice showing the evacuation routes in case of an emergency, along with all other rules and regulations. This is the plat of Riverland Terrace. So staff does believe that for this application, all 3 of the criteria may have been met. Thank you. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 0824-00802, a special exception to establish a short-term rental and extended home rental in the low-density R4 zoning district at 2040 Wapu Drive, TMS number 343-0300141 on James Island in Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. The board may modify any of staff's recommended conditions below, including but not limited to restricting the number of days that the short-term rental may be rented. In the event that the board decides to approve this application, the board should consider the following recommendations by staff. Prior to the zoning permit approval, the applicant shall not complete the short-term rentals limited site plan review process. The use shall comply with all requirements of Article 6.8. The property shall not be used for more than 144 days in aggregate during any calendar year, and the property owner shall be responsible for ensuring that the tenants comply with the Charleston County noise ordinance. Are there any questions?
Any questions of staff? None. Thank you once again, sir. Is the applicant present? Yes, sir. Please come forward. Please state your name and address for the record, and please tell us why we should approve your application, sir.
Hi, good evening. Thank you for your time. My name is Robert Gates Roll, and I live at 2040 Wapu Drive, Charleston, South Carolina, 29412.
So please tell us why we should approve this application, sir.
My wife and I bought this property in 2019. It's our full-time residence. We've since had 2 boys, a 3-year-old and a 5-year-old. Our family's getting bigger. COVID happened. We needed more room, so we decided to build a garage addition, and with the hopes that we could offset some of the cost of it with the short-term rental. We feel like the area in our neighborhood that we're in is appropriate for it. It's a high-energy part of the neighborhood. It's not a quiet street or the back of a cul-de-sac. From the beginning, we've been very transparent with our next-door neighbors who are on the side of the property where the rental is. We actually have a letter from them stating that it's been no issue and that they've been on board the entire time. And with our limited short-term rental permit, we have been renting it since April with 0 complaints, no incidents, and we're very selective. My wife personally manages it. It's received 5-star reviews so far, and we have ample off-street parking. I understand that parking is a concern, street parking in this area, because there are businesses nearby that do not have off-street parking, but we do plenty of it, and we use it, and we do not allow for people staying here to park on the street. They have a place in the driveway, and so do I, and so does my wife. We see it as a way to support the local businesses around us. There are a lot of small businesses around us, as well as have no real impacts on the residential neighbors nearby. And that's that.
Okay, very good. I'm out of curiosity, you mentioned that you live next door?
No, we live on the property.
The main house.
The home was built in 1947, and we broke ground in early 2023 on the garage addition, which is the rental. It's mainly for my parents and my in-laws to have a place to stay, and storage in the garage for all the stuff we need for the kids. We've had to modify our house. When we bought the property in 2019, there was a dilapidated brick structure there that I was going to convert in for the purpose of housing the grandparents. And I found out it was just a tear down. There was no use. So if anything, we've improved the property. Including the main house, which we've torn all the siding off and put up good new stuff, replaced all the windows, taken out all the damage. We put a lot of work into this place to make it better. And this is one way to help us pay for it. And we're a young family. It's tough out there, tough enough. And so this is a way to kind of take the edge off.
And you mentioned that your wife will be doing the managing of it?
Yes, she does.
Okay, good. I'm very, very, very proud that you have 5-star ratings. So what vehicle of advertisement are you using, sir?
So far, we've used Airbnb.
Airbnb. Okay. And what is this across the street from you? I did take the liberty to drive over to this project.
Yeah.
But what is that? What I see all the cars right across the street from you there?
Right across the street from us on the Plymouth side is Postcard. It's called the Charleston Postcard Company. It's a warehouse for paper product distribution. And then on the other side, it's a building. It's a mixed-use business building. There's a State Farm agency. There's a pottery studio. There's a hair salon. And I think there's a little gym around the corner there. And then the opposite corner is a church. Behind the Postcard Company on Wapu is an auto shop. And then there's a yoga studio and then a restaurant.
You got a lot of traffic
And
there.
all of these businesses have, some of them are established, but several of them have emerged in recent years prior to buying the place in 2019. There is traffic there, and there's a lot of walkers. People come, I think, and just park just to walk in the neighborhood. We've got the poorhouse and all these kind of high energy businesses, especially on the weekends. There's a farmer's market, and so it's a lively place. It's like living in town, and we like it.
Very good. Any questions on my right? On my left? Thank you so very much for your testimony today, sir.
Yes, sir. Thank you.
Do we have anyone else to speak in favor of this application? Anyone else to speak in favor? Do we have anyone to speak in opposition to this application? Anyone to speak in opposition? Very good. This application is closed to the public. Board members, do we have any questions of staff? Do we have any other general discussion? If not, I'd like to entertain a motion. Mr. Neal?
Yeah, I'll make a motion here. Case BZA is 0824-00802, special exception approval. I will make a motion to approve the special exception approval criteria for this application. I feel it meets all three of the criteria. It is clearly compatible with the uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. This is a very prominent community over there, and if they had not liked this, our room would be packed. So, and there are other short-term rentals, extended home-term rentals in that area clearly. Provision 2, adequate provision is made to exist such items as setback buffering, including fences, protect adjacent properties from the possible adverse influence, STRP. He's got his own driveway area for parking, so normally we have problems with noise pollution and parking, and this takes care of, they've adequately handled all of this. So, and they're currently using it as a short-term rental already, which is one of the things I really like to, makes it easier for me to approve the extended home rentals when they're already operating as a regular rental. So I see it clearly complies with that. And then the last criteria is complies with all applicable rules, regulations, laws, and standards. They're currently operating at, there's nothing that staff has brought it to our attention, violations or anything like this. So I think this is a clear, easy way to get approval, and this is the way it should be done textbook. So I'm looking for a second.
Very good. Do we have a second? Second. Mr. Nelson, we have a second from Mr. Nelson. Any discussion? Very good. All those in favor, please indicate by saying aye and raising your right hand. Aye.
All right.
Any opposed? There are none. Congratulations, sir. Your application has been approved. You'll be getting information from staff in the next 10 business days. Thank you so very much, and you have a great evening. Okay, we're back up again with Mr. Joshua Downey. Our next case is case BZA 0824-00801.
All right, so BZA case 0824-00801. The applicant property owner, William Johnson, is requesting a variance to locate a proposed detached accessory structure, a swimming pool, to the side, not wholly to the rear, for an existing principal structure, and to reduce the required 35-foot critical line setback by 8.6 to 26.4 for a proposed swimming pool at 2315 Spearfish Circle. TMS number 32803000070 on James Island in Charleston County. The subject property and surrounding properties to the north, east, and west are located within the R4 zoning district, and the southern portion of the property backs up to the Oak Island Creek. The 0.043 acre subject property contains a single-family residence that was constructed in 1985 per Charleston County records. The Oak Island subdivision was platted in 1976, and Charleston County adopted the required setbacks for the buffers for the OCRM critical line in 2001. So that is the Chapter 4 definition for the low-density R4 density and dimension standards. That is the zoning map, the 300-foot radius map, that is an aerial view of the subject property, a zoomed out aerial view of the subject property. So this is 3 other properties within the Oak Island neighborhood. 2 other properties within the Oak Island neighborhood that have swimming pools that are close to that OCRM critical line. So staff did conduct its site visits on September the 20th and September 24th. So that is the subject property. That is the proposed site for the pool. That is Spearfish Circle. So here's the survey of the property. The site plan. And that is a plat. So staff believes that it may meet criteria 1, 2, 4, 6, and 7, and that it meets criteria 3 and criteria 5. So the board may approve this application, approve with conditions, or deny BZA case 0824-00801, a variance to request to locate the proposed detached accessory structure, a swimming pool, to the side, not wholly to the rear, for a existing principal structure, and to reduce the required 35-foot OCRM critical line by 8.6 feet to 24.4 feet for a proposed swimming pool at 2315 Spearfish Circle, TMS number 328-03-00070 on James Island in Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. Staff does not have any recommended conditions. Are there any questions?
Yes, sir, Mr. Neal.
Yeah, so can you go back to the site plan that shows the pool? I'm a little confused on where the 35-foot line is and how it's impeding. They're basically just asking for 8.6 feet in the critical line. So I'm trying to understand where are they crossing it? Where's the 8 feet? Can you show me on that?
So
or am I missing something? I can't really understand it on this map. I see where the pool is, but then is that dotted line that's right on the edge of the pool, is that the critical setback line? And because they're not going over that. So, but then there's a small swale. Is it for the small swale? But this might be for the applicant too. So I'm just trying to understand.
Yes, I believe that small swale is where it encroaches in where it's closer to the OCRM critical line.
So it looks like the small swale is the 8 feet that it's getting into. So really the pool is not in the critical line setback, it's only the swale?
The swale, but it would be permitted as one structure. That's
right.
Why it's...
No, I understand. So basically the landscaping is what's causing the issue. Well, I'll follow up with the applicant more then.
Thank you, sir.
Thank you.
Any other questions on my right? On my left? Thank you. Thank you, sir. Is the applicant present? Very good. Please state your name and address for the record, and please tell us why we should approve your application.
Good evening. I'm William Johnson, 2315 Spearfish Circle, Charleston, 29412.
Thank you, Mr. Johnson. We already have one question at you, starting off.
Yeah, I'm happy to clear that up. I came into this meeting and kind of hesitated to tell you guys that I'm a pool builder.
Uh-oh.
So I do think that full transparency is the way to go. So with that being said, the property is my home. It's my personal home. I'm not building a pool to sell the house or anything like that. You know, I deal in this industry. I've been in the pool building industry for a decade in Charleston. we design, build, maintain, service swimming pools. We always get permits before, which is why I'm in a position of asking for this variance on the front end and not building it and then seeing if we can not tear it out.
That's funny.
With that being said, no, the actual, Mr. Neal, to answer your question, the pool itself does extend as designed 8.5 feet into the critical line setback,
So
which
it's
is
the critical
35
line,
feet.
the dotted line that was up, that was.
Yes, sir. So
Okay.
the marsh side, the last 8.5 feet of the pool extend into that critical line setback of 35 feet. It also has a critical line buffer. All these setbacks have buffers. You know, they have a buffer. Ours is 15, and then they have a setback that's 35. I think the original kind of reason behind these buffers, the buffer's always a little more restrictive. So the buffer is meant for not disturbing the vegetation and that type of thing. The setback is more for, you know, new construction, not to come in there and impede future water flows or, you know, not to keep things from draining. Currently, right now, we have a large driveway. If you look in that picture, it's a pretty big lot. I've looked at all different design aspects of where this pool could be best suited. The pool is 16 by 30, which is a little bit smaller than the average residential pool in Charleston. So we're not asking for, you know, a crazy large pool. Just like some of one of the previous cases, we bought the house a couple of years ago. We did know at that point in time it was very close to the marsh. I wouldn't even try to put a pool in the rear.
Yeah.
It just wouldn't make sense. I would want to do that. The house actually extends like 15 feet over. So, you know, the first thing was, can you have a side yard pool versus a rear pool, which is what we usually go up against on the business side for some of our clients. On this side yard pool, it was a way to offset the old driveway, which we don't really use, and is also is an impervious surface for drainage and runoff. Actually, if this pool was approved as designed, the total impervious on the lot would actually go down by 300 square feet. So the lot would drain as a whole. It would be a better situation. That swale is not affected. That swale is on my property, and it is it's very efficient at moving water. In lieu of some of these recent storms, we definitely want to be able to move water out of that cul-de-sac and to keep that swale maintained. The pool would not go into the swale area at all. It's you know, we looked at putting the pool in the front yard, which is pretty big, but we have a septic system out there that's pretty large, and I think actually that would probably be less beneficial overall to the neighborhood as a whole to have a swimming pool in the front yard. But the way the pool is positioned, it doesn't extend. It actually doesn't extend as far as the house currently does to the marsh. No existing vegetation would be changed. I don't think any, you know, I think the reason for some of these setbacks and these buffers is to protect the vegetation, and also in the event of a large storm or a storm surge would be, you know, to not compromise the structural integrity of the soil. A swimming pool shell out would almost act like a bulkhead in this case. All of our neighbors, we've checked with them. I think a lot of them have written. Okay, I've got time. Sorry.
Yeah. You did good.
I'll help them out.
Go ahead.
So back to my original question, is the setback, the critical line setback on the rear of the property or the side of the property?
It's on the rear of the property.
Yeah, it's on the rear.
Yeah.
That's after looking over the stuff. So then that's the rear setback is the one that you're, and what's going to go in that back area? Nothing else. So does your steps to the back of the house sit in that critical setback?
They do.
We won't go down that road, will we? I'm good, Mr. Chair. Thank you.
How wide is that swell, Mr. Johnson?
Currently, that swell from kind of the tip to tip of it is about 4 feet.
Okay, very good.
That's fine.
Any other questions on my right, left?
Good.
Excuse
Thank
me.
you.
Mr. Neal Nelson?
So your driveway to access the property, you saying you're removing the driveway or just turn it into a shell sand?
We're going to be removing the driveway.
Okay.
Right now, we have out in the front, you can see from some of the pictures. I actually kind of came up with some pictures. I could pass to you, it's kind of the way it looks now and the way it would also look. The swimming pool would be completely screened from the road, whereas right now at the end of the cul-de-sac, you have just a view of the driveway. But everything would be screened, and we have a existing gravel parking area out front that primarily gets used.
Okay.
I do have one follow-up.
Go ahead.
Since we have a pool expert here, how do you have the pump area so far away from the pool when it's on the main house?
So the pump, it doesn't matter how far away the equipment is these days with the efficiency of it. Everything's pressurized inside the 2-inch pipes.
I just thought it was strange that you had to pump all the way on the other end of the house.
Well, I'm pretty sure that we're going to have to elevate the equipment, and that's where the HVAC system and everything is, so it kind of makes sense,
Yeah, it makes sense
to bank everything together.
No, I think it's great. Thank you.
My question to you, why it took you so long to build your own pool and you building for everybody else?
Well,
I'm
that's
just
exactly
teasing. Don't
why it
answer
took
that
so
question.
long.
Don't answer that question. I'm just teasing you.
And just to confirm, you did not build a pool on Edisto,
I did
correct?
not, thank God, build the pool on that stuff. But I did feel bad for
If
her
he comes to a
position.
few more of our meetings, he can get some clients.
You almost got a new one tonight.
All right, let's wrap this one up. Thank you so very much for your testimony,
Sure.
sir. Do we have anybody else to speak in favor of this application? Do we have anyone else to speak in favor? Do we have anyone to speak in opposition?
Yep.
Yes, please.
Oh, you know that. You don't want no pool.
Hi, I'm Susan Kershaw. I live at 3605 Berry Hill Road on Johns Island. And again, I kayak on Oak Island Creek a lot, and that's such a beautiful area. I want to start by saying that I really respect the decision you made on the fire case this evening. I mean it when I say that you guys have a tough job, and you guys see all the cases. I don't see all the cases, and so, again, I just respect that, and I'm really just here to add weight to the marsh as a consideration in your minds. Our world is changing. Storms are getting bigger and more powerful, and the sea level is coming up. And I think the calculations in our heads need to change as we think about protecting our coast and our waterfront properties and our marsh. So this case doesn't give me as much agita as other cases because it's not in the buffer. It is in the setback, but it seems like there's other places on the property this pool could go. It does seem like, as I go through the criteria, that there is nothing extraordinary about this piece of property. And none of that applies to other properties in the vicinity. If you look at the overhead, the aerial about all of those properties on Oak Island Creek, there's a bunch of them that are on cul-de-sacs, and a bunch of them have houses right up on the critical line that were all built ages ago. And so they're just, I don't think this meets criteria 1 or 2. There are a few pools, but we don't take that into consideration when making these individual decisions about individual cases.
Okay.
As time
Thank
up?
you. Yes.
Okay.
That's okay. That's okay. You did well. I thank you so very much. Let me see if any board member has a question for you. Do we have any? Mr. Nelson?
Ms. Kershaw, thank you so much for having a passion for the salt marsh and just being willing to come and endure these meetings just for the 2 minutes of fame for making the comments that you wish to make. Really do appreciate you taking the time to do that.
Thank you.
Anyone else? Thank you so very much for your testimony. Do we have anyone else to speak in opposition? Anyone else? Very good, then. This application is closed to the public. I take that back. You have the right of rebuttal. Where are you? You have the right of rebuttal. I'm sorry.
I would just say, Ms. Kershaw, I'm also very environmentally conscious, and I take that in consideration with all the pools that I build on a weekly basis. And regardless of how the vote goes, anytime you're out in the creek and you feel like stopping by, well, you're more than welcome. So, thank you.
I got one question.
Mr.
For him.
Jordan? Yeah, Mr. Johnson, if you could come back to the podium, please, sir. Mr. Jordan has a question for you, sir.
I shouldn't say this, but I just can't resist. Do you build swimming pools for drainage? For drainage purposes?
We don't build them for drainage purposes.
Obviously, somebody must.
Yeah, that threw me for a little bit of I was scratching my head on that one earlier. I will say that swimming pools, they actually act as catch basins in a storm event. A lot of times, in my situation with some of these larger storms that we had, I would actually drain the pool down about 3 feet and use that as a catch basin to keep any flooding that might happen around the house. So,
Thank you.
thank you.
Thank you, Mr. Johnson, for your testimony. At this time, this case is closed to the public.
There you go.
And yes, I'll gavel it again. Nevertheless, board member, do we have any questions of staff? Do we have any other discussion at this time for this case? If not, I would like to entertain a motion to either approve or deny. Anyone from this side? Mr. Nelson?
Mr. Chair, I would like to make a motion to approve BZA case 0824-00801. I do believe that the variance request meets all of the approval criteria, that one, there are extraordinary and exceptional conditions pertaining to this particular piece of property. I'm compelled mostly by the fact the house was built in 1985 in a neighborhood platted in 1976. That was a long time prior to the 2001 initial passage of Zeldar. That will drive a lot of the reasons for me believing it meets all the criterion, that including criterion 1. So for criterion 2, these conditions do not generally apply to other properties in the vicinity. While it would apply to all of Oak Island, as we look at Charleston County as a whole, we certainly don't have as many neighborhoods that were platted prior to 2001. So we meet that criterion. For criterion 3, because of these conditions, the application of the ordinance to this particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. Again, because of the location, the house was built in 1985. That's the primary driver for the need for the pool to go to the side. The applicant has done a very good job of minimizing the impact to the critical area buffer, so I believe we meet that criterion. For criterion 4, the authorization of the variance will not be of substantial detriment to the adjacent property, to the public good, and the character of the zoning district will not be harmed by granting of the variance. The applicant has testified that they've actually coordinated with their neighbors, and their neighbors have no issues with placement of the pool. So we meet that criterion, and he's provided adequate screening as well to really protect the visual intrusion that may occur to their neighbor's property. For criterion 5, the BZA shall not grant a variance, the effect of which would to allow establishment of a use not otherwise permitted in a zoning district. We meet that criterion. For criterion 6, the need for the variance is not the result of the applicant's own action. Again, for criterion 6, I fall back on the year the house was built and the neighborhood platted as causing the need for this variance more so than the applicant's desire for a pool. And for criterion 7, the granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. We clearly meet that criterion as well. There are no conditions from staff, so that is my motion, Mr. Chair.
Okay.
Thank you, sir. We have a motion that has been properly moved and second. He caught me on that one, Mr. Truslow. Any discussion, questions? Mr. Jordan did the second. Any discussion?
I'd like to say, while I'm going to be in support of this motion for the reasons that Mr. Nelson articulated, particularly that the house was constructed in 1985, it was platted in 1976, the setbacks weren't established in 2001, So compelling reason has been made. At the same time, I'm sensitive to what Mr. Kershaw has said, and thank you for coming expressing concerns about the environment. One of the comments I would make is that we have these environmental laws for a reason, and if we're going to, and we shouldn't just give a blanket approval to anything at any time. Otherwise, there's no reason to have these laws if we're going to grant an exception in every case. But this one, given the dates that Mr. Nelson has articulated, we have a basis for doing this. I'm sure I can see Ms. Kershaw nodding, she understands. And in fact, also to be added, there it appears that this pool is going to enhance the environment rather than detract from it, especially the way I understand it's to be constructed. And thank you for that. So I hope Ms. Kershaw understands my reason why I'm supporting in this case. But I don't think we should have a blanket rule. We have to look at each case on a case-by-case basis. And if we're going to, in the future, if we're going to approve every single one, we might as well not have a rule. Thank you.
Thank you, Mr. Truesdale. Mr. Neal?
Yeah, I'm going to support the motion. I do want to say that this was a good learning experience, at least for me, on this one, and I really hadn't thought about it before. But they're putting in a swimming pool, which you would think would take away pervious overall square footage, and he's actually increasing it. He's taking up the driveway. So maybe in other applications, that's something that I'll be looking for to be more sensitive to for the environmental stuff, to help with the standing water and the water retention and stuff like that. So I think that's a great way to look at it. So even though they're taking up the driveway, if we didn't approve it, they'd leave the driveway, and more of the surface area would be harder for the rainwater to disperse. That's just something to notch away in your brain memory bank. It's a really good thing.
Very good. All right. Any other comments? Thank you. All those in favor, please indicate by saying aye and raise your right hand, please. Aye.
Aye.
What was that? Okay, yes. It was unanimous. Where did you go? Congratulations. Your application has been approved. Within 10 working days, you'll get information from staff letting you know the next steps in the process. Congratulations, sir, and good night.
2 more.
All right, we're on the...
Down to 2.
Yes. Ms. Workins, please bring us home.
Okay.
So, next case, BZA 08-24-00803.
Yes. The applicants and property owners, Richard and Angela Ballman, are requesting a variance to reduce the required 15-foot interior side setback by 8 feet to 7 feet for an existing unpermitted detached accessory building porch at 5335 Log Bridge Road, TMS number 24600000111 in the St. Paul's area of Charleston County. The subject property and surrounding properties are located in the agricultural residential AGR zoning district. The 1.20 acre subject property contains a dwelling that was constructed in 1985, a utility shed constructed in 1995, and the unpermitted detached accessory building porch that is approximately 70 feet by 50 feet in size. So, this is the building in question, and then this is the house, and this is the shed. This is the zoning ordinance requirement, 300-foot radius map. Here's the aerial. We posted the property and visited the property on September 20th, 2024. And yeah, these are photos of the building. Sorry. And this is a close-up of the area that encroaches. So primarily it's the roof of the porch, but there is a little section of the actual building that's within that setback. And the plat. Regarding the approval criteria, we stated that it may be 1, 2, 3, 4, 6, and 7, and that it meets 5. The board may approve with conditions, or deny the request based on the board's finding of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, we have one suggested condition that the applicant's property owners shall obtain all required zoning and building permits for the unpermitted structure.
Okay. Well, thank you, Ms. Working. Mr. Neal, you have a question, sir?
Yeah, just real quick. So this came about from what I'm understanding, if I read this right, they're going to be doing a renovation on their main house, but this, when they started researching everything, we found out we got a unapproved
Correct.
piece of parcel that we got to deal with, and that's what they're coming for. And it's only, they're moving the setback 7 feet, 8 feet,
10.
and it's for the overhang, or is it for the actual structure?
There's a little bump out you could see that's part of the structure, and then, yeah, primarily it's the overhang.
And this is for the unpermitted structure. This isn't for the main house. This
Correct.
is for the unpermitted structure.
Right.
All right, this is, okay. Thank you very much.
Anyone else?
I have
Yes, sir.
questions.
Okay.
For this building, does it have, is it electrical? Does it have plumbing? What's it got inside?
Or I don't know that. I didn't visit the property, so I'm not sure.
Applicant, that's a great applicant question.
But if it does, yeah, we'll need to get the permits for all those.
We can ask the applicant about that.
Okay, we can ask the applicant about that. The
I'm sorry.
second, I had a second question because I'm usually in favor. I'm the deferral guy that wants to make sure I've got all the information so I can make a decision. Is this a case where we should perhaps consider a deferral to see why? I mean, it's quasi equitable principles that are involved. Is this a case where we should perhaps seek the contract to see who was responsible for what in this instance? I'm not sure it'll make any difference, given the disposition of the lawyer swimming pool case. But is this otherwise an appropriate case where we should find out why something happened? And I say that because I don't want to encourage by a contractor not getting a permit, the applicant not complying with zoning. I don't want to be in a position where we're encouraging people in the future to just violate the law and then come back and ask for forgiveness.
Right.
Is this
Hopefully the word's getting out.
is this a case?
More and more people are getting ticketed than before. But yeah, unfortunately, the decision is that this board then has to figure out whether or not to keep the portion that is within the setback.
Okay. I was just asking,
Yeah.
has it been discussed, or is this something we should ask the applicant?
You should ask them.
Okay, thank you.
Okay. Any more questions of staff? Thank you, Ms. Working. Is the applicant present? Thank you, sir. Please state your name and address for the record, and please tell us why we should approve your application, sir.
Thank you, sirs. My name is Richard Ballman. I live at 5335 Log Bridge Road, Hollywood, South Carolina. My wife Angie and I live there.
Very good.
We've been living up in Kershaw County, Elgin, South Carolina, for 25 years with our careers. This property was my father's. He passed away in 2016. I bought the property from the estate, and we chose to move back to Charleston, where we're both from, and make this our permanent home. My dad built the home in '85, and it's in need of a lot of upgrades. We have secured a loan, and we have money in the bank of over $500,000 to do a major restoration to this house. I enjoy woodworking and things, so we built a pole building on the property so that I could have storage of all my tools and things. I love to grill, so we've got a number of grills, and we built this lean-to off the back of this pole building for storage of that, my grills, tanks, things like that. And I realize that we are beyond the setback line, and we're asking for consideration of this, please.
Okay. Let me see if any board member has a question for you. Anyone? Mr. Neal?
Easy one. When did you build the accessory structure?
In 2021, and late 21 and
COVID,
20.
late COVID. That's after COVID, I guess. And then to follow up on Mr. Truslow's question, what's in that shed? Is it just a shed? Is it you call it a lean-to, and I know what that means in my brain, but I mean, is there power in it and stuff like that, or?
Yes, sir. I have electric and plumbing in the pole building.
Okay. All right, thank you.
I had,
Let me get one in. You know, what do you utilize that pole building for?
Great
The
question.
other one, what do you have, the plumbing and electricity?
The building itself is, again, storage for all my woodworking equipment, lawnmowers. I've got lots of chainsaws. We own a 30-acre piece of property 1 mile away. It was the little farm that my mom and dad raised us on. And so this was my dad's property. He owned both places. We have acquired both of them from the estate. And to maintain the farm, we call it, I need lots of equipment. I've got 7, 8 chainsaws, a lot of grass cutting equipment, that type of thing. So that's what we use the pole building for.
Okay. Mr. Nelson? Thank you, sir.
Yeah, by any chance, was there a structure there of any type before you built the building?
He said he's got plumbing and stuff like that in it.
There is another small building on the property, yes, sir.
Was there anything where you built the pole building?
No, sir.
Okay. All right, thank you.
Mr. Jordan, you had a question?
No, but I'll tell you, I'm from Chesterfield County.
Oh,
So
boy.
I know where you come from.
Yes, sir.
And I'm glad you're getting your dream. I'm just sitting here worrying. I hope you get paid that $500,000 off.
It's going to take the rest of my life to pay that.
Hobby.
Well, we decided to take Daddy's home, make it ours. We're going to do an addition to it. We're going to put a lift in so that when we get older, we'll be able to get in and out of it. So
I've done something similar. I bought what I should have inherited, my grandfather's farmhouse in Chesterfield County.
yes, sir.
So I'm doing the same thing in reverse. Good for you.
Well, and let me just add, and we put this in our notes. This is a small slither of property that was owned by our family for over 200 years. Chaplin's Landing, I'm part of the Chaplin family. And so much of our ancestors' property is sold and been built and developed. And so this, along with that little 30-acre piece of farm, is just me trying to hold on to some family property.
Good for you.
Yeah, good for you. Good for you. Thank you so very much for your testimony.
I will add that Logbridge Creek is a very unique creek in and of itself. That's a beautiful spot. I live across the river from there and have fished along that creek many times. So.
I try to do as much as I can.
Well, he got all the grills. That was probably an invitation, but thank you so very much for your testimony now. I'm just teasing.
Thank you.
Anybody else to speak in favor?
I had a question. He may have
Oh, would you
answered it, and I
please-
may have just missed it. This space is not suitable for living space. I understand. Is that correct?
To be very honest, yes, sir. My wife and I are living in this building at this time.
You mean the shed?
The shed, yes. It does have a commode. It does have, we're making it, this is our office. We put the farm into an LLC. We're wanting to eventually use it as a business to try to lease paddocks and pasture for horses and things. And so we built or incorporated about a 700 square foot office in this building. And right now we've got a bed in there, and that's where we're sleeping, because we were hopeful that we were going to get the permits to renovate the house. That's why we already had the loan money in our hands. And so we went ahead and started evacuating the house, and we moved all of our furniture into this pole building, and that's where we reside.
So it's got, what I had missed, and the reason I'd asked is I think you've answered it, but you got a provision for septic, you got toilet, shower, you got bed, you live in, I appreciate your honesty, but you're living there. Who provided for you'd think you have to get a permit to get a septic tank. You got no permit, no zoning. Did anybody get a permit for the septic?
No, sir.
Okay. Well, again, I appreciate your honesty.
We are retro permitting the entire building. So right now I'm working with a septic engineering company. DHEC has been involved. We're working with a structural engineer to verify that the building meets all the codes.
you just made if I can paraphrase, you made an innocent mistake. You didn't know you were required to get the permit and the zoning, or you left it up to the builder.
That's right, yes,
and
sir.
To take care of these things, and you just honestly saying, how did this thing get found out?
They're doing a renovation on the main house.
When you did a renovation, that they found out about this?
When we began to seek a permit to restore the home, I think that's when the aerial view showed the whole building.
Okay. One last question.
That's my assumption, sir. I don't know how this came about, but.
One last question for this board. I'm the person that usually asks for deferral so we can gather information and try as best we can to get it right. What would you be in favor of, or would you ask for a deferral so we could get your contract with your contractor to see who was responsible for what?
Can you elaborate
Or
a referral?
A deferral.
Deferral?
What we could do is we can vote today on, thumbs up, thumbs down, so to speak, or you can ask for a deferral so that we could gather so we would have information about what responsibility. If the vote turned out bad for you, you'd be protected if the builder didn't do what he was supposed to do. So I'm trying to see if you would be in favor of that option. You don't have to do it, but it's just an option that's available to you.
I'm going to decline and accept your decisions.
Oh, all right.
Okay. Good, Mr. Downey.
In the event that the board does approve this application tonight, after doing the site visit, believe Ms. Working and Ms. Clark and I discussed that to us it met the criteria for an accessory dwelling unit. And so if the structure is permitted tonight, what you're looking at is just the structure being permitted where it is. At the staff level, we can change it from an accessory structure to an accessory dwelling unit if it has the criteria that it meets that the setbacks and everything. So I don't want y'all to get caught up on whether it's an accessory dwelling unit or it's an accessory structure. That's something staff level we can permit and make sure that it has the proper septic and everything at that level.
Thank you, sir. Mr. Neal.
I'm just confused. Sorry, I had to step out for a second. I might have missed this, but there's two buildings on there, or is it one building and a shed?
I have a home and the pole building.
Okay, but the pole building is the one that is non-permitted, correct?
That's correct. Yes, sir.
And the pole building is the one that needs the 8 feet more of the setback, or does the house need the 8 feet of the setback?
The pole building.
The pole building.
The lean-to off the back towards the line.
But you're not living in the pole built. You're living in the house, right?
No, sir. We're roughing it in the pole building right now.
Who's living in the house?
Nobody.
Because it's in disrepair and needs.
We were earlier in this summer, May, June timeframe. We began applying for the loan.
Okay.
The loan process went through. The closing occurred. We got money in the bank. We got a licensed builder who's going to modify the house.
That's fine.
Yes, sir.
I was under the understanding that you were living in the house and you had the pole built, and that was the problem, and then you're going to do the renovations. But you're really roughing it. Okay, that's not going to change the way I'm seeing this project, because it's an unpermitted structure that you're trying to bring up to compliance. And from that standpoint, I always applaud people that are trying to bring it into compliance. However the issue happened, you're trying to do it the right way. My question will be for staff at the end on a motion, but I don't need to take the applicant's time right now. Thank you.
Any other questions? Thank you so very much for your time. Anyone else to speak in favor? Anyone else to speak in favor? Anyone to speak in opposition?
Nobody here.
Well, I have to say it anyway. Okay, very good. Then this case is closed to the public. Board members, do you have any questions of staff?
Yeah.
Yes, sir, Mr. Neal.
So is there a staff recommendation that addresses that the the lean-to, the structure, the unpermitted structure needs to comply with all building codes afterwards, or should that be added to a motion?
Yeah, they will have to if you, it is the submission.
Yeah,
Okay.
and then also
Okay.
too,
I missed that then.
Also too, when we permit it at the staff level, whether it's an accessory dwelling unit or a accessory structure, building permits require
Right.
on all residential structures.
No, I'm fine, Mr. Chair. Thank you.
Thank you. Any other questions of staff? Any discussion? Very, very good. Uh-oh, I'm sorry, I didn't see you.
I was impressed by the honesty of the applicant, and they enjoy an excellent reputation, and their family does as well, and I'm appreciative of that. I'm concerned when we have seems to be a precedent of builders not complying with the law, and then an unsuspecting homeowner finds out about it, and there's no consequence for a violation of the law. It's safety related, it's environmentally related, and that causes me a lot of concern. We've got these laws for a reason, but if it seems to me if we allow builders to come in, not comply with the law, not ensure that things are properly cited, and then he takes off and goes away, that it shows it encourages people to violate the law. It doesn't have respect for the law, and it seems to me to be a downhill trip. So that's my take on it. I want to be consistent in what I've said. I'm aware that we've allowed the lawyers to violate the law, not get a permit, not get zoning variances. So I don't know how it plays out, but that's my take on this. I just don't feel like we can ignore relevant criteria at our whim.
So let me just make a clear point, if I could. I guess probably not age-wise, but one of the senior members on this board. I believe one of the responsibilities of this board is to grant relief if there is some undue hardship. And yes, there probably could be some other source of recourse that this applicant may have taken, could have taken, but to what extent? So I do applaud you for your criticism. I do applaud you for your vote that you're going to make, whether in favor or in opposition. And we need more people like you to continue to think and vote the way you vote. So be diligent and be strong in how you vote and how your opinion states, because all this is public record and it is not going unheard. And we will make a determination based on whatever the facts are presented, all pertinent facts. So, and every application I've seen over my tenure is different to some extent. So I would give you that level of encouragement, and also would just hope that you would embrace that little bit of knowledge that I
have tremendous respect for you, and I appreciate that we should grant relief from a hardship. I would be more inclined to vote in favor had the applicant said, I'll show you the contract and who was responsible for what dialogue they had regarding this after this was discovered.
Yes, sir.
So that's kind of, I would appreciate the hardship, and I would be inclined to favor, I know what the result's going to be, but I would have looked at this more favorably had he agreed to deferral, so we could gather the information to know what happened and why. And the next time around, if it came up again and we saw that there was a problem with a builder who had done this in various places, we or the county would know what to do the next time. So that's going to be the reasons why I'm going to vote the way I am. And I hope the applicant understands that to me, it's a hardship on one hand that I'm in favor of. On the other hand, the respect and compliance with the law, not necessarily for them, to make sure that unscrupulous builders aren't allowed to do these kind of
So
things.
that's why you were up on it.
All right, thank you.
Very well. Let's keep this down to a minimum.
Yeah,
Please, sir.
I'm just gonna, the only thing I would say is, I mean, we all agree or disagree on all these different topics every time. But the one thing that I have learned from my year and a half on this board is that we stick to the criteria and we're consistent to the criteria, even though every case is individual. And sometimes I'll lean a little bit more into one of the criteria because it's something I'm passionate about or something I think has been unrepresented. And sometimes it's like, well, how did you vote that way? Because, well, everybody looks through that lens a different way. And as long as we're upholding to the criteria and you have your one vote and everybody does it the way they want to do it. And then if you come out on top, you come out on top. If you come out on the bottom sometimes, every one of us has been on the side where we haven't won, but we've stated our purpose. And I think that's why this board is doing a very, very good job.
Okay.
Thank you.
Thank you. Thank you. So at this time, can I entertain a motion to either approve or deny?
Mr. Chair, I'd like to make a motion that we approve this request for case number BZA 0824-00803. In making this motion, I do believe that the applicant has demonstrated that they have met all 7 of the criteria necessary for the variance. That there are extraordinary and exceptional conditions pertaining to this particular piece of property. I'm compelled by the applicant's testimony that they have purchased the home from the estate from his father, and just the idealism that exists with rebuilding the house or renovating the house to make it livable again, and the process of just trying to renovate everything to bring it into compliance. I'm compelled that we meet criterion 1. For criterion 2, these conditions do not generally apply to other properties in the vicinity. Again, as the applicant has stated, that there are other properties in the vicinity, but they're not governed by an HOA, and there are multiple properties with ancillary buildings that do not meet the county setback ordinance. And while we can't meet this criterion based upon the lack of others in the area also not meeting that criterion, the simple fact that this property is a narrower lot and maybe with a little more proper planning could have met or not have needed this variance request. The fact that the structure is there and has been constructed, that I believe we can claim that we meet the criterion for criterion 2. For criterion 3, because of these conditions, the application of this ordinance to this particular piece of property would effectively prohibit and reasonably restrict utilization of the property. Again, the use of this building as a temporary residence while they're renovating the house, it's definitely necessary that it be there. There's probably other information that we could have requested during the testimony, including the location of septic systems and other such structures on the property that might have given some additional reasoning for encroachment into the side setback. But with a lack of response from any neighbors adjacent to the property, and the fact that the building is now constructed, I do believe that we meet that criterion. For criterion 4, the authorization of the variance will not be a substantial detriment to the adjacent property to the public good. Again, we have not received any negative correspondence for this particular application, so we meet that criterion. For criterion 5, the BZA shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted. Clearly, we meet that criterion. There is no change of use related to this variance request. For criterion 6, the need for the variance is not the result of the applicant's own actions. I understand my board members' concerns about not having access to the contract, but I do believe that in the event this request were made previous to construction of the building with adequate evidence, we probably would allow such a variance. And the fact that it's mostly an overhang that encroaches upon the side setback, I do believe that we can meet that criterion. And the applicants now, as we get into the special conditions, the applicants will be required to bring everything else up to code, so I believe we meet that criterion. And for criterion 7, that granting of the variance does not substantially conflict with the comprehensive plan or purpose of the ordinance. We definitely meet that criterion as well, given that there's really no change in the use of the property. In making this motion, I would also include the one special condition requested by staff.
Second.
That is my motion.
Thank you. We have a motion that has been properly moved and second by Mr. Neal. Any question or discussion? All those in favor, please indicate by saying aye and raising your right hand. Aye.
Aye.
Any opposed? There's one. Very good. It carries. Congratulations. Your application has been approved within the next 10 days. You'll be getting information from staff letting you know the next steps in the process. Thank you for your time and congratulations. All right. Last but not least, every vote counts. 804. Case BZA 08-24-00804.
Okay.
Be done by Ms. Workin.
The
Thank you, Ms.
applicants and property owners, Leona and Theodore Forbes, are requesting a variance to reduce the required 50-foot front street side setback, the required 15-foot side setback, and the required 30-foot rear side setback for existing unpermitted detached accessory structures at 5732 and 5728 Anglers Pond Lane. And this is TMS numbers 281-00-00205 and 281-00-00206 on Johns Island in Charleston County. The subject properties and surrounding properties are located in the agricultural residential AG 12 zoning district. Lot number 12, which is TMS 281 ending in 206, is 0.32 acres. Lot 13, 281 ending in 205, is 0.33 acres for a combined total of 0.65 acres. Both lots are owned by the applicants, and they plan to combine the lots into one lot. The existing wood-framed single-family residence was renovated in 1998 per Charleston County records. It is a non-conforming structure because it is located 10.98 feet from the rear property line and is only a couple of feet from the side property line. So that's the structure here. But this is not part of the variance. I'm just pointing out that this is an existing non-conforming structure on the property that existed prior to 1998. That's just when they did the renovations. So then, more specifically, the property owners need a variance for the required 15-foot side yard setback by 8.78 to 6.22 for an existing unpermitted 19 by 8 foot by 7.9 feet shipping container with a connected open shed, which is 12 by 10.7. So that's the structure, oh gosh, up here. And then it also does not meet the rear setback, so they need a reduction by 22.34 to 7.66 for that same structure. Then the required 50-foot setback is not met with this existing shed here. And they need a variance by 6.7 feet to 43.24 feet. And that's for a 7-foot by 12-foot shed. Staff conducted our site visit on September 20th, 2024. This is the zoning ordinance requirements, the 3-foot radius, the aerial maps of the property. Opposed to the property. This is the lean-to, so this is the one that needs the rear and the side setback variance. The one on the right's the shed. And the one on the left is the lean-to, the structure. You can kind of see the shed a little bit in there, but barely. So. Site plan and the plat. Staff stated that it may meet 1, 2, 3, 4, 6, and 7, and that it meets 5. The board may approve approval conditions or deny the case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following condition. 1, the applicant's property owner shall obtain all required zoning and building permits for the unpermitted structures. Questions? Yes.
Yes, sir. Mr. Neal has a question.
So if the lots are going to be combined in the future, why is the side setback requirement needed?
So the lots are going to be combined here. I'm somewhere in there. I can't really see, but
Well, the sides, I understand the
but
rear
this side,
setback.
this is a side.
Oh, that side, on
Front.
the very end.
Yeah, front, side, rear. So
It's not
this
for the middle
needs a
structure?
side and a rear, and this needs a front. So no matter if it's combined or not, it's not going to settle the
So
setbacks.
which one is the container? Where's the container?
That's in this corner,
Oh, okay.
and then the shed's here.
The shed that has the lean-to on it?
No, so the container has the lean-to on it. That's
Right, that's what I thought. The shed.
That's the container with.
And that's the one that's in the corner?
Correct.
Okay.
And then the picture of the shed is this little white shed in the.
That's the white shed there.
Yeah.
And that is where? On
In the
site map?
front.
That's in the front?
Yeah. So you see the house is here,
Right.
and then this is the shed.
All right, well, I'll have some location questions for the applicant. But
Okay.
that'll be okay. I'm sure they'll be armed with all that information. Thank you, Mr. Chair.
Yes, sir. Anyone else? I know you had a question. I know what your question is.
I had a question, but Mr. Neal very capably
I read his mind.
Stole it away from you?
asked the question.
I read his mind.
All right.
So what I understood was if you consolidate the lots, you'd still have a setback issue that we
Because
would
it's on the end.
have to deal with anyway.
Yeah.
Yep.
And they're probably I'm not telling them what to do, but they're probably going to consolidate the deed as one anyway.
Come on
Although not
forward.
required.
Just think of it this way: if it didn't have to come to this board, I wouldn't bring it to the board.
Please come forward.
If it could just be.
Please state your name and address for the record, please, ma'am.
Leona Forbes,
Yeah.
5732 Anglers Pond Lane, Johns Island, 29455.
Now, please tell us why we should approve your application. So you've already heard some of the discussion we have about your plot.
Yeah.
And if, Ms. Workin, if you could just bring up the plat, would be great.
Yeah.
Speak into the microphone for us if you can. I
Okay.
can't hear you. Thank you.
Okay. I'll just start out by saying when we've owned this property for a long time, the lot 12 we got in 2003, and then which has the container on it, and lot 13 we got in 2004. We also own the lot where the container is. That lot next to that is ours as well, and we did own the lot on the other side of that, where the house where we lived in for a long time and built. And we retired and thought we were going to downsize and just live in a tiny house. And this is how it came about. The dwelling that we live in was already there when we purchased the property. The people that we bought it from, they were living in it. It already had power and septic, but we just used it as storage all the years because it was right next door. So when we decided to sell our house a little over 2 years ago, that was the reason we got the container, because we didn't have any storage. And not knowing, it also shows a chicken coop on there, which we have since got a demo permit and took that down, so that is no longer there. But when we purchased it, since the building, the little barn house was already there and they were living in it, we just assumed that you don't have to get a survey when you buy a property. It's not required, and we just assumed it was okay, and just. I don't know how other way to put it. We put the container in a place that we thought wasn't an eyesore. It was level. There's a lot of trees there, and it just fit right in there without disturbing any of the vegetation or trees. And we didn't think it bothered anybody. You couldn't see it from the road. So, and like I said, we needed it for storage. We needed a secure storage. And when we put the other little metal storage piece in prior to that, it wasn't there a month before somebody just came and yanked the door open, even though it was locked, and, helped themselves. So that was why we got the container. We didn't realize that we were putting it too close to the back or anything like that. So, I'm not sure what else to say. I mean, we kept up the barn building over the years because why not? We fixed the siding when it went bad. We painted it and so forth. And we never cut the power off. We never, turned anything off. We just always paid the taxes, took care of it, kept it mowed, kept it neat, and just used it for storage as well. And so we, like I said, sold our big house and decided to live in a tiny house.
Okay. Let's see
And
what.
I don't know. Yeah.
Okay. Mr. Neal has a question for you.
Sure.
I have two, if permitted. So my first one is there any reason why the shipping container, because you're already doing some changes to your plans, it sounds like, and you're taking the chicken coop down, so that's good.
We did that, yeah.
Well, let me ask this other question first, and then I'll come back to the shipping container. The property that's behind you, it says is owned by Caroline Fine, a
Yeah.
very large property. Is that got any housing on it or anything like that, or that is just undisturbed, beautiful, natural land back there?
It's gorgeous.
Okay.
There's nothing on it.
So
at
obviously
this
you don't
point.
really have neighbors. It's not like you have a noise complaint or anything like that. Who wants to live next to a chicken coop anyway? But so then that brings me back to the shipping container. Although these variance requests, I see why both are here. One's for the rear because really of the wood frame residence and the shipping container, and then the side setback looks like it's mainly for the shipping container. So if you were to move the shipping container into a more reasonable location, since you're already tearing down the chicken coop, maybe that would be a better solution. I can't draw your plan for you, and I'm just asking. I understand the setback requirement, the setback request because of the wood frame residence. You bought it. You're going to remove the lot line. You're not going to tear down the house to redo it. No reason to do that. But moving a shipping container is not that difficult unless it's. I mean, that's something I'm asking. Is that a feasible? Let her answer unless she wants to come and talk afterwards. I think is what the chair will probably say. So that's why I'm asking. Is there a need for the shipping container to stay right where it has to be right now?
Well, there was a couple reasons why we put it where it was because of the trees and stuff we didn't want to cut down. And on the other side of that lot, there was a huge sunken area, which was caused because after Hugo, because we bought that property not too long after Hugo, there was a huge tree there, I think, that had been killed from Hugo.
Mm-hmm.
And when the tree died, it just kept sinking in, and we've been throwing, so we couldn't put it on the other side where there weren't trees.
Could you put it closer to the wood frame residence or closer to the other shed?
It's all trees.
Wasn't there a pic? Can we pull up that picture?
Is there
Right.
overhead?
Right. No. I was going to just go back to the one.
Yeah, and see where the house is, diagonally from the house in that open area is the drain field to the septic,
Okay. Well,
which was already there.
That's a logical explanation.
I'm sorry?
That's a logical explanation. That's why we're trying to find a way to
Yeah.
to fit
And-
these things in. All right. That's fine for me, Mr. Chair. Thank you.
You had a question, Mr. Truslow?
No, sir.
Anything over here? Thank you so very much for your testimony tonight.
Okay.
Sir, did you want to speak? You the last person in here. We drug you out. Thank you so very much for your testimony.
Thank you.
Seeing that there's nobody else here to speak in opposition or favor, any question for staff? I'm going to close it to the public. Board members, do we have any questions of staff?
I don't.
Do we have any general discussion? Mr. Truzzo.
I'm actually surprised in my vote. I know that there wasn't a permit and there were perhaps some zoning issues, but I'm inclined to support the request in this case for the following reasons. They own both.
Are you making a motion, Mr. Truzzo?
I'll make the motion.
Okay.
That he is.
I'll make the motion in this case.
Please proceed, sir.
If I could, I move to approve the request in this case, which is BZA 08-24-00, I think I'm correct, 804. Based on the evidence presented, I would find that a strong case has been made. I'll explain why, for the board more than for the applicant, some of my thinking in this case. First of all, any violations have been inadvertent, and the violations are technical, and I would use the word as a lawyer, de minimis. I mean, it really didn't stated another way, using basketball terms, I'm fond of.
I can't use big words like you.
For Mr. Neal, who doesn't understand, no harm, no foul. Both parcels are owned by these people. There's been no opposition. This is a simple, as I see it, we're dealing with a placement of a Connex or shipping container. I call them a Connex. It was placed where it was for good reason, for the benefit of the environment, the trees, and so forth. I believe that all the criteria set forth, and these are the criteria that are applicable, that are set forth in 3.10.6, 1 through 7 have been met. There are exceptional circumstances that relate to this property, given the dates, the 0.65 acres of property with a single wooden framed residence. It's been renovated. I would look at its, again, I've said it's any inadvertent violation has been and will be de minimis, and there's been no objection. Number two, the conditions do not generally apply to other properties. Number three, because of these conditions, this particular, it would unreasonably restrict, and I'm mindful of what our chairman had to say about being reasonable in harm. I would find that it would be unreasonable to make them change in this case. Number four, I think they're all fit in with one another, but the authorization of a variance would not be of a substantial detriment to the adjacent properties, and in fact, they own one or both. They actually own both properties. Number five, I think, is obviously met. It meets that clearly, that we shall not grant a variance, the effect of which would be to allow establishment of use not otherwise permitted. And I'm talking a little faster, but this will be part of the record because this is the shank of the evening for us. Number six, it may give us a bit of a concern for the need of the variance is not the result of the applicant's own actions, but I also look, and again, I'll use a term for Mr. Neal would understand, and being a golfer, that sometimes you just play them as they lie, and they certainly didn't want to put this Connex in a place where it would sink down and cause further problems. So I would submit that 6 and 7 have been met. The granting of the variance does not substantially conflict with the comprehensive plan. And again, I'm reminded of the comments that our chairman has made about trying to do justice where it's appropriate. And this is a case where it's appropriate. I hope that satisfied the requirements for us to grant this.
With staff comments?
I would make this contingent upon compliance with the recommendations of staff, and I understand that the applicant has no objection to those. I would just incorporate that by reference. There's only one that they obtain all required zoning and building permits for unpermitted structures.
Second.
Thank you so very much. We have a motion that has been moved and seconded. Any question or discussion? Very good. All those in favor, please indicate by saying aye and raising your right hand. Aye. Aye. Any there were no that oppose. So very good. Congratulations, your application was approved tonight. after your long stay. We appreciate your patience, but within 10 days, you'll be getting information from staff letting you know the next steps in the process. Thank you once again, and congratulations.
Yeah. So I finally have good news. We only have 3 cases. Woo!
Wow.
Good night.
And we can start at 5.
We might as well do those 3 tonight.
Why don't we defer?
That's
until
real
December?
funny. We are not ready for that.
Thank you. Thank you for coming.
Thank you.
Why don't we defer?
I'm not going to be here. I think I told you.
And then Mr. Jordan is going to get with me. Yeah, you just need to do 1 hour.
And we lost Mr. Williams, right?
Yeah.
Will the babies come first and the wife?
We'll be getting a newbie. I won't be the newbie anymore.
Yeah, several people's terms run out. Tanya and Mark, theirs runs out too. Their term. Marchant.
Who's the second?
Ms. Switzer Smalls.
Who's the second one you mentioned after her?
Jesse.
Jesse was,
I thought you said somebody else's term was running out. Mr. Marcher.
yeah, and Mr. Ray, but Mr. Ray I think is gonna reapply.
Good.
Yeah. Yeah.
He needs to.
If we didn't have him between,
I don't know, after tonight, he may change it. Oh, stop it. I'm gonna be transparent.
Yep. All right, thank you. We're adjourned.
Y'all. All right. Good meeting. Good meeting, man, Mr. Lawyer.
Yes, you said 5, right?
5 o'clock.